see us too. You're right here. I would, and they should like straighten it a little, you think?
Yeah.
Knock it off the stand.
Well, we'll just straighten them up.
Is that better? Maybe, that's right. Yeah, that's,
Ma'am, will you all talking from the podium, or is it,
pardon me?
will you all be talking?
I would assume so.
We're trying to put our microphones on.
You'd have to ask the prosecutor, I think we will.
We will
Unless the judge
You're definitely
says
going
so.
to, so you can see your
Unless the
client.
judge
Right,
tells us
well,
otherwise.
Everybody want
see
to
the
move?
doctors,
Yeah, that's what I meant.
Thank you.
Yeah. 2, 3.
I was thanking her first, I was thanking you.
You want me to pinch a move towards both?
Here, you want me to put one of those up on the
Yeah.
podium?
No faith in
We probably don't.
plans, so. I think we're good.
Yeah. It usually takes a minute.
Is it from here? Yes, power.
Yeah,
There we go.
there we go. That one, I had to hold it in a little harder.
Let's figure out an option. Yeah. He says not gonna have it. Okay, well, what can you do to make it better? You can't do it, I mean, so is mercy gonna be thought, is my question. Okay, well, that's all I'm asking. That's what I'm asking.
Be seated, please.
Start.
If everybody on the Zoom can mute themselves.
Good morning.
Good morning.
You all hear me?
Yes, I need one of my mic.
Yes. Okay, thank you. I'm not sure who said that. That was the judge. Was that, Your Honor, Judge, is that you that said that?
1 second. All right, can you hear me?
Yep, I can hear you.
Okay. All right,
Can you hear me?
yes. All right, if everybody on the Zoom could mute themselves for now.
That's the judge, yes.
Excuse me, Judge.
Yes.
This is Naomi Mallett. Ohio Moss. We have some concerns before we begin.
Wait, hold on 1 second. Well, we are on the record.
Okay.
Yeah, okay. We are on the record in case 693-409, State versus Delonte Hardy. If Mr. Hardy's counsel can introduce themselves for the record.
Your Honor, on behalf of Mr. Hardy, Bluffs I.
Chris Julian.
Frank Hollow.
Linda Rico.
And on behalf of the state,
You Judge Kevin Filiatro, Dan Cleary, and Detective John Dayton here from Cleveland Police.
okay. First, before we get started, I've issued an order regarding defendant's presence, and that was today. I basically reiterated what I had said during our last hearing, but has counsel made that determination of waiver?
Your Honor, we agree that this is a legal issue only, just like we said last time.
Okay.
We understand the court's ruling.
Okay, all right. I did want to go over some legal, making sure that we all understood what the four corners of the legal decisions are and what's being asked of the court to decide today. My first concern regarding that is because I want to be able to understand what the parameters and what the specific issues are being asked of this court to determine whether or not it's appropriate to have the doctors here for that portion of it. Because I'm going to be basically stating what I believe needs to be proven through not only the statute, but case law. Do you understand what I'm saying?
That's fine.
Okay. State, do you have any?
No objection.
Okay. And I'm sorry, for the doctors that are here, we have Dr. Hendrickson who's here, and then ma'am, you were about to introduce yourself?
It's Naomi Mallett. I'm Deputy Chief Counsel with Ohio Moss. I think, we just had some concerns about our physicians testifying in a public hearing for this purpose. And so wanted to talk with you about that first.
We are at the hearing now that had not been raised prior to the hearing date.
Did not receive a hearing notice or the court.
My bailiff actually picked this date in conjunction with your own doctor's schedule because I understand at least one of them was on vacation. Okay, so
Yes,
for now, go ahead.
Respectfully, the forensic evaluation process and the report that is filed under statute is confidential. And so there are just concerns being raised that our physician, and one of them being the forensic evaluator, and one of them being the treating physician who is bound by physician-patient privilege, testifying in court in a public hearing.
Okay.
Not
All right. So for right now, I'm going to put you, is it just your one Zoom account that's in the room?
Yes, I am here with, yes.
All right, I'm going to put you in the holding room for now anyways, because we're going to discuss some legal issues first. Okay. All right. So I reviewed the parties' briefings regarding this, and I just wanted to, because this is an issue generally of first impression, so to speak, we do have some guidance from one case that the parties have cited to, but this is one of relatively first impression. So I wanted to get the four corners of what this court is going to be deciding. And so the first issue that I think is being contested is whether or not the statute permits tolling when the court finds that the defendant is incompetent to stand trial, but a substantial probability that the defendant will become competent to stand trial within 1 year if the defendant is provided with a course of treatment. Does everybody agree that that is essentially what's being asked of this court today?
Thank you, Judge. On behalf of the state, if I could, we do have the pending motion filed on April 4th of this year, asking the court to consider those words and whether treatment was actually occurring or whether a tolling event was occurring when the defendant was refusing medications at this facility. And so that's the motion the state plans on pursuing today.
And then, so there's sub-issues to that.
Okay.
That's why I wanted to keep going, but,
Yes.
so essentially, I think from the defense's briefing, I think it's twofold. One, you're stating that Barker only permits tolling as far back as the forced meds order. Is that accurate?
Judge, I mean, this is sort of the substance of what we would be expecting the testimony would outline, but.
I'm just talking about the legal standards.
As a preliminary matter, well, we don't agree that any tolling events have happened here, but in terms of the parameters of what you're talking about, yes, we would say that it doesn't go any further than the forced medication order.
Okay.
Anything before that
Okay.
is what we'll be talking about today.
And then I think subsumed in all of this, when I read Barker and the statutes and all the accompanying statutes, and I'll get into that in a moment, what constitutes treatment, essentially? That's your secondary. You're saying even if it goes back, I think one of your arguments was treatment can include many things. And frankly, what is treatment that is necessary for rehabilitation, or what the doctors believe to be treatment necessary for rehabilitation? So I just kind of wanted to go over, and I'm going to explain what this court's research has found so far. And I wanted to go over Barker, I wanted to go over the statutes, comparing and contrasting them as Barker did with some other statutes. So essentially what has happened here is Barker, there was and I'm going to also compare and contrast it to this case. So I'm not entirely sure that Barker anticipated or actually answered this direct question. They do, in their analysis, discuss what constitutes treatment and what constitutes a tolling event, an equitable tolling event. I think that it wasn't specifically asked. The trial court in Barker simply retroactively stated that the tolling would go back to December 16th of 2003 in Barker, okay? That was when the petition was filed, right? Now, the difference in Barker is I don't think that that wasn't an issue that was contested on appeal. There was no issue stating, trial court, you're wrong, it should go back to the date that he first refused. The difference here is twofold. One, they weren't asked that. Two, in Barker, the defendant was committed to the facility on December 1st of 2003. The petition for forced meds happened 15 days later. And when you read Barker, I'm just going to read a little bit from it. It says, the upshot of the foregoing facts is that Barker, due solely to his own actions, failed to receive medication needed to restore his competency for approximately 14 months from December 2003, so they just generalized December 2003, through January 2005. after refusing his medication, obtaining a trial and a stay. So once the forced meds order went into effect, it was an immediate stay. So there was a long period of time in which he was not being treated with forced medications. It says, on appeal, Barker contends the plain language of 2945.38 establishes that a person charged with a felony cannot be required to undergo treatment to restore competence for more than 1 year. Barker insists that treatment may include alternatives other than medication. Therefore, he asserts that his refusal to take medication was not a refusal of treatment. Barker's position was not upheld. Barker's position was not accepted by the Court of Appeals, and that's essentially one of the facets that the defense is stating. Well, he was treated, but even though it didn't include medications, that treatment counts medications. And then moreover, he argues that the statute does not provide for tolling based upon the defendant's refusal. The Barker court accurately noted that 2945.38 does not address the impact of Barker's refusal to take medication, and there's no Ohio case law on point. They looked at the Connecticut Supreme Court's reasoning in State v. Garcia, and I'll just note, again, State v. Garcia, on page, and that's 233 Connecticut 44, I actually went and I read that, and I also read the statute in Garcia that they relied upon. And the Garcia statute is actually more restrictive than ours in regards to timing, and I'll explain that in a minute. It says, finally, we must address an issue that is not raised by the parties, but that is necessary to be considered in light of our conclusion that this court has jurisdiction over an interlocutory appeal. So again, they didn't specifically address whether or not it goes back to the date of refusal. They specifically only addressed in sua sponte whether or not the period should run while there was a stay and while it was on appeal. The practical effect of an appeal they discuss. Thus, it is impractical and unduly prejudicial and burdensome to allow the state of Ohio to allow the commitment time limit to run while the defendant's appeal is pending. And so Barker went a little bit even further than that, and I would also say that that specific question wasn't asked of in State v. Garcia. And State v. Garcia's, the statute that's similar to ours, is more restrictive as it comes to time. And it says, Barker's refusal of medication and his failed appeal of the trial court's forced medication order consumed virtually all of the 1-year period available for treatment. Under these circumstances, we see no error in the trial court's application of equitable tolling principles to prevent Barker's own actions from depriving the state of an opportunity to have his competence restored. Finally, we find no merit in Barker's claim that forcing him to receive treatment beyond the 1-year period found in 2945.38 violates his constitutional rights. Based on the reasoning set forth above, we conclude that Barker did not undergo treatment within the meaning of the statute for more than 1 year. He refused medication, which was a necessary component of his treatment, and his actions told that 1-year period. So it wasn't specifically asked and stated, even though the trial court just happened to toll it back to the date the forced meds application was 12/16. It wasn't specifically contested, and all of the language in Barker points to his refusal of medication, which was a necessary component of his treatment. And it even goes on in paragraph 10. A defendant like Barker may not be required to undergo treatment for longer than 1 year. However, Barker did not, quote, undergo treatment within the meaning of 2945.38 for longer than 1 year. Instead, during the 1-year period, he actively resisted in taking medication, and that was including his time on appeal. Accepting Barker's argument would allow him, rather than the medical professionals, to determine the scope of treatment available to restore his competence. And I looked at, a couple other statutes that had addressed this tolling issue, specifically Wisconsin. Wisconsin v. Green, 2020 AP 298. In that statute, the language in the statute, if the language of the statute is, if the court determines that the defendant is not competent but is likely to become competent within the period specified in this paragraph, if provided with appropriate treatment, the court shall suspend the proceedings and commit the defendant to the custody of the department for treatment for a period not to exceed 12 months or the maximum sentence specified. Wisconsin v. Green found that the statute describes the 12-month time frame in terms of commitment rather than treatment. Although the custody under the statute must be for the purposes of treatment, it is the custody, not the treatment, that may not exceed 12 months. And so when you look at Wisconsin 971, there's code section 971.14, subsection 58A1, they made a distinction between the time frame connected to commitment versus treatment. And in our statute, which is, I think, more broad and it is more focused on treatment than commitment, it specifically says defendant will become competent to stand trial within 1 year if the defendant is provided a course of treatment. And I'll also note that Barker states that he refused medication, which was a necessary component of his treatment. So after reviewing all of that, I went back and I looked at the specific, and again, in State v. Cell, it also has a part in there, and I think it's either page 180 or 186, about having to look at the individual factors or the individual circumstances of a case. And so our case, for whatever reason, unknown to everybody, because we can't oversee the day-to-day operations of Twin Valley. The date of admission in our case was October 22nd of 2024. Dr. Hendrickson completed the capacity assessment for forced meds on 3/14/25, 3/18/25. Two other doctors completed their independent evaluation for forced meds. So we had 148 days, nearly 4 months and 25 days in between when he was delivered to when Twin Valley applied to this court for forced meds. Nobody had any indication that anything else was happening. Again, this is left to be determined, but we were informed thereafter that he had had some issues having to go to the hospital. On 5/6/25, this was an email that I received and sent to counsel that defendant is taking medications consistently. So there was a very large chunk of time as opposed to Barker, which the court did not make a specific determination that it only goes back to the date of application for forced meds. And in fact, all of their language encompassed the defendant's refusal. And even more specific in this case, I want to go over the fact that in his history, you have the unique circumstance where he had previously been found incompetent and given specific medications to restore him to competency, which in fact did restore him to competency. And it was noted in every single psychological report that he had oftentimes refused medications. And so I'm just going to note for the record, the first report that was done in this case was by the defense. You privately engaged Dr. Wood to assess the defendant, and I'll note that the conclusion by your own doctor was, and this is as it goes to if given the necessary treatment, if provided with a course of treatment, as it states in the statute. And under Barker, refusing medication which was a necessary component of his treatment. Your own doctor wrote in its report that these medications were a necessary component of his treatment, and I'll read from page 14 of the doctor's order. So after reviewing all of the case law, all the statutes, specifically what happened in Barker, specifically what happened in this case, it says, if Mr. Hardy receives psychotropic medications and is provided with a course of treatment, it is my professional opinion that there's a substantial probability he will become capable of understanding the nature and objective of the proceedings against him within the statutory time frame of 1 year. On that same page, she notes his history. His psychiatric symptoms also resulted in Mr. Hardy being previously found incompetent to stand trial, and he subsequently received outpatient competency restoration treatment, which included psychotropic medications, and then he was ultimately found restored. And so your doctor specifically states that the treatment required of him includes psychotropic medications. And so there has been, even by your doctor, a standard for which they believed, and he was transported to Twin Valley to undergo this course of treatment specifically. And this is, as we all know, schizophrenia, which, you can ask the doctors and again, there might be a case out there where somebody is treated without psychotropic medications for schizophrenia that has alleviated those symptoms and been restorable, but his history belies that. His history was very clear that when on psychotropic medications, he was restored to competency, and when he was not, he decompensated. Your own doctors state that this is a necessary form of treatment for him. And then I'm going to go to the court psychiatric clinic. And so Dr. Woods was August 19th, 2024. September 9th, 2024, it was this court's psychiatric treatment. This doctor, Dr. Songer, stated that the findings from this evaluation are also consistent with Dr. Woods' findings in her report dated August 19th, 2024. It says, Mr. Hardy was previously restored to competency in April of 2024 after completing competency restoration treatment in conjunction with a medication regimen. His symptoms are likely to improve if he engages in the proper course of treatment and competency restoration in this current case. When he was transported, all of the doctors in their own reports that were eventually given to this court all included the previous reports, and which included even after he became competent and he was restored to competency, his own decisions to not take the medications due to side effects, including decreased libido, and these were accurately documented, and everybody has adopted that documentation and has adopted the findings. And so, that's where I have gotten to in this point when I analyze the case law, the statute, what it means for treatment, what it means for tolling, and our statute is, the way that it reads in comparison to other statutes is specifically, and I think that the Wisconsin Supreme Court stated it nicely, as the way that two different statutes can be formed is 12-month time frame in terms of, it describes the statute, the 12-month time frame in terms of commitment rather than treatment. Our statute consistently in 2945-38B1A ties it to treatment. If 1 year, if the defendant is provided with a course of treatment. Again, no defendant shall be required to undergo treatment, including any continuing evaluation and treatment under Division B1 of this section for longer than whichever of the following periods is applicable. 1 year, in our case, 1 year. So tolling issue is a new one. It's factually dissimilar from Barker. It's factually unique because we do know what even your own doctor believes to be necessary treatment that he was not getting for over 4 months, almost 5 months. That's nearly half the time period for restoration, which Barker specifically stated, you can't avoid this forced medication order. It would enable him to avoid the effect of a forced medication. Accepting Barker's argument would allow him, rather than medical professionals, to decide. And it says Barker did not undergo, in quotations, treatment within the meeting for longer than 1 year. And again, so I'm finding that the statute is tied to treatment. And so my question, I guess, having understood what this court's analysis is, and also looking back that your own doctor has stated that the necessary treatment includes psychotropic medications, because I know part of your argument, either in oral or written, or both actually, was that what he was engaged in for these 4 months when he was refusing medication counts as treatment. But your own doctor says that the necessary treatment includes psychotropic medication. And so that's where I start off with, from a legal component, about what are the parameters of what are the fact findings that we need to determine. Does anybody have any questions about what I've said so far, or have anything that they want to point out in any of the case law?
Judge, if I could just
Go ahead.
offer something briefly. Appreciate the court's analysis. Respectfully, we would suggest that the purpose of this hearing is to explore some of those issues in greater depth. We would also suggest that Barker establishes a relatively rarely utilized principle, and it's a principle that is factually, as the court pointed out, factually dissimilar to what we're dealing with here. So as the lawyers would say, as we would say in law school, it's distinguishable. It's factually distinguishable from what we're doing here. Barker is not Delonte. And what we think that the court needs to listen to, and what we expect that the testimony would establish here, is the parameters of his treatment and whether the doctors believed that he was in fact engaged in a course of treatment during the time that the state is asserting he was simply just refusing any medication. And that would be the issue that Barker allows you to decide under the parameters of Barker. That's within what Barker says you can decide. And again, Barker was an egregious situation where he was utilizing all kinds of procedural, the court called them, I think, he was utilizing procedural shenanigans in order to try to run out the clock. That is absolutely not what's happening here. We just simply want you to listen to what the doctors have to say to evaluate what they believe the proper course of treatment was, and we don't believe they can establish that the state can establish that he was simply refusing all treatment. That's what we think the parameters of this hearing should be.
And that's what I'm going back to. And then we can listen to the doctors regarding whether or not he was engaged in treatment, but I think the question remains, what constitutes treatment? And, when I was going through all of the legal analysis, it dawned on me that I hadn't reread the initial reports in quite some time. And when I went back to read the initial reports, even from your own doctor, it struck me that even your own doctor says that the necessary treatment includes medications. And on top of that, and so when you say engaged in treatment, that's why I brought this up specifically. One, because when I went back and looked, it was right there in black and white in writing from the doctor that you engaged and submitted to this court, and all stipulated to, I'll add, that the accurate course of treatment, and I'll note, not to lay it on even thicker, but in your brief, on page, I'm not sure, section E of the defense's brief, it says, Mr. Hardy was deemed incompetent to stand trial by 2 independent doctors. The state of Ohio stipulated to these findings. It is not an inconsequential position. So everybody stipulated to these findings, and one of those findings was, in fact, your doctor stating that psychotropic medication is necessary part of his treatment, and he was not receiving that. And so that's where I kind of go back to. So what is the definition of treatment? what is the definition of necessary treatment to restore to competency. And then, the other thing I'll note is, it's not just for this case, but for every conceivable instance, it wouldn't make a whole lot of sense. I'm just thinking back to when I was thinking about it, what are the other circumstances in which a defendant would not receive the necessary treatment, and would that toll? For example, during COVID, when we had drug shortages, supplies, if for whatever reason the drug vital to and necessary for his treatment wasn't available, would that allow the clock to run? So in other circumstances where a defendant is not getting the proper psychotropic medication that has been deemed and stipulated as necessary, what if it wasn't available? Would that also toll the time, or would that allow the clock to run? Supply chain issues. There's other circumstances, but in this case, we have a defendant that has had a history of refusing medications, not based upon, bodily autonomy issues necessarily, even though it kind of intersects, but based upon his belief that he didn't need him, and that's even after he was competent. And the records show, and I can go back, that once he started receiving the injections, the first time he was given treatment, it was only a few months that they rendered him competent, and then he decided not to take it again. So we can go, I just wanted the parties to understand the analysis, and I wanted you all to also have the ability, when you do ask questions, what specifically the court is going to be deciding on. What is the necessary treatment? And again, I point out the fact that your own doctor says the necessary treatment is psychotropic medications.
Judge, if I could, we're prepared to hold this hearing. We were prepared the last time we were in court. I actually have 8 exhibits because I do believe this will likely, or this could be appealed, all right? And within those exhibits are many of the same reports you're talking about. But I think even a more fundamental thing I'd like to say at this point is this. We relied on their doctor's report. We relied on our doctor's report. They agreed on that exact thing. Delonte Hardy needed both medications and treatment. Not one or the other, both. And when the defense and the state stipulated to it, that's our agreement as to what treatment is under the statute. And that's exactly what the court was thinking when the court journalized it in the order sending Delonte Hardy to Columbus. And so for these reasons, the state feels that there is almost a collateral estoppel situation that could apply here to the defense. The defense should not be allowed to even argue that medication is not necessary for treatment, when that was part of the agreement both parties came to, and this court endorsed when it accepted those stipulations. And so those are the first 3 exhibits we had, Judge.
And I'll just have to say, it was, again, I don't know the reasons why we weren't alerted, but it was shocking to know that he had not been taken, and we were only notified, almost 5 months later. Every case that I've had, consistent actually with Barker, who also went to Twin Valley from 2003, a recent case that I had was less than 2 months I was notified. And so for 5 months, it's unclear why that happened. But at the same time, and I think that there was times where he maybe took, this was in the record before, that he maybe took it for like a couple days but then refused, and it never was able to take effect.
So,
that the medication does have a time frame in which it becomes effective, and he never took it for a long enough time for it to become effective, and he would stop taking it on his own volition.
So, and that's why, and if I could approach with these exhibits, that's why we did have State's Exhibit 6 in here, which is the transcript from that hearing, because that was testified to, that he had not taken medication since November of last year. between November and when they were asking for the forced meds, he hadn't had any medication. So frankly, when it comes to the parameters of this hearing, I think the one question that needs to be asked is when was the last time Delonte Hardy had medication? What was the date in November? Because we know from their testimony, sworn testimony, he didn't have it from November until this court's hearing, March 31st. Can I approach with these?
Yes.
Thank you. The defense is aware of all 8 of these exhibits.
Your Honor, we have had an opportunity to look at those exhibits. We're aware of those exhibits. We would just ask that they be placed under seal for obvious reasons.
And I think I discussed, the court might also add its own exhibits, and I can do this, with the parties regarding some of the correspondence that my bailiff had received that I had sent on to counsel. Just for example, we got an email on 5/6, with some additional information, including on 4/21, 4/28. So anything that my bailiff had received from them via email was forwarded to all counsel, and it had additional information in it, which we've gone over, I think, to this point, but I will actually print it out and make it an exhibit. If there's no objection, we can go over those exhibits at another time. Does anyone want to address the issue brought up by Twin Valleys Council just now? The issue that I have is it's only in extraordinary circumstances in which I can close a courtroom. They have their own issues regarding their doctors testifying. I am not permitted to expel members of the public or the media at this point, the local rules have changed since maybe the last time some of you were in my courtroom. They explicitly reversed the local rules where victims or witnesses were able to request not to be recorded. That has since been changed by the Supreme Court, and now I cannot, it used to be a balancing test, whether or not the media could be here. Then it changed to the court needs to inform the victims and witnesses of their right not to be recorded in any way, shape, or form, and I could expel the media. There was some issues that were brought up specifically also by the media and me in the case that I had, whether or not that is constitutional, and the Supreme Court in their local rules changed that. So there are rules on whether or not I can expel anybody from this courtroom. Ohio courts are probably the most open public forums there are. So does anybody have any other comments based upon the law on whether or not I can expel anybody from this courtroom?
So these are public proceedings. I believe what the court's saying about the rules and such. I don't think that there's anything in the statute that makes these hearings any different than any other hearings that occur in the courts in the state of Ohio. I think it is worth considering, though, what testimony we need today. Because, like I said, the defense agreed through their doctor in our stipulations, which is State's Exhibit 3, which is the journal entry this court created after the stipulation to States 1 and 2, their doctor's report being 1, State's doctor's report being 2. They agreed that treatment was medication and treatment. And so, because they made that agreement then, I think they can't make the argument now that it's something different counts. Medication has to be there in order for treatment under the statute to occur. So I think really the only question that needs to be asked of these doctors today is when's the last time Delonte Hardy took medications in November?
So
that's it.
This
If I
is.
can respond to that because I didn't
Go ahead.
interrupt, if I could.
Go ahead.
Just very quickly. With respect to my friends on the other side, we are not arguing that there was no reason for medication or that medication wasn't necessary. What we would like the court to examine through these doctors is the interplay between various kinds of treatment strategies that the doctors used and medication, and how the doctors believed those were tied together. So we want you to look at what the course of treatment was that the doctors decided. We are not arguing that Delonte should not have had the same medication. So that's point number one. Point number two, I don't know if you want me to address the closure argument, because I mean, obviously none of that has been raised before today, but.
Correct. But
So that's
before we
surprised us as
before
well.
we get to that, my position is and always has been that when I make a legal analysis, this is why I started with that. It's because this is the path that I had found after reviewing everything, so that I could give you all the parameters. But this is a case of first impression, and although my analysis has led me to this conclusion, I think it's important that, particularly, if not always, but particularly on a first impression, that everybody be able to make a record. And I'm not going to foreclose any questioning. So now you can get to the closure of the courtroom.
Your Honor, the statute 2945-371 does provide that all of the psychiatric evaluations are under seal. If a party asks for them to be under seal, they must be under seal. It also indicates that the court shall not provide access to the report unless the party seeking access can demonstrate that access to the report is necessary for treatment of the defendant or for a criminal adjudication of the defendant for which the report was created. Based on that,
So can you give me
I
that?
do have
Hold on.
concerns.
One second. I want to just re-review that statute. Can you give it to me one more time?
Yes, it's 2945.371. Subsection H.
And so there are many cases, both civil and criminal, where things have been filed under seal. But that doesn't always translate to whether or not there should not be an open hearing based upon what had been filed under seal. So I just want to re-review it. Is there anything that you have found where it would preclude or require that this court close the courtroom?
Your Honor, as I think my co-counsel has said before, this was new to us, and perhaps the best way to address this is to have counsel for the Department of, OMAS be on the screen with us to make their arguments.
Okay, all right, just give me one moment. Okay, so I'm just going to read from some of this. But the report, so it lists the persons that are permitted to access and review this sealed report, but the report shall not be open to public inspection. So the report itself shall not be open to public inspection. A person who is not among those permitted to inspect the report as described in this division may file a motion with the court seeking disclosure for good cause. When a motion for disclosure of a report is filed, the court shall notify the defendant of the pending motion and allow sufficient time for the defendant to object to the disclosure. If the defendant objects to the disclosure, the court shall schedule a hearing to determine whether the party seeking access has demonstrated that access to the report is necessary for treatment of the defendant or for criminal adjudication of the defendant for which...
Or for what?
Sorry. Or for criminal adjudication of the defendant for which the report was originally created. So it's specific to the report, and I understand the argument by extension, the report is going to be discussed. And then it says, report necessary for treatment of the defendant or for criminal adjudication of the defendant for which the report was originally created. That's a very nebulous term because I've already made a distinction between, criminal adjudication on the merits, which, the defendant has a a right to, well, he has a right to be for all, but for these legal proceedings, as it relates to competency, we're allowed to hold these hearings as it relates to competency, and it's not stayed. There's competing interest that, you know, I'm not permitted to close a court, and I've had many cases where something has been filed under seal, and then in adjudication of any legal issues during the pendency of the case, it's discussed in open court, it's testified to in open court by experts and such, and I have not been asked to excel the public or the media. There are competing interests here, and I'm not sure that this has been adjudicated. We might have two issues of first impression here, because I have not, and it appears that nobody else has any case law, but we can permit the Twin Valleys Council to come in and see if there's anything. We're kind of doing this on the fly, which I don't like, because there's a fork in the road. Either we go forward or we don't. And I want to make sure that this is done properly. Okay, I'm just looking at Lexis, just trying to see if there's any case law. Of course, I obviously haven't had an opportunity to read it, but the case notes in Lexis has a section, public records, psychiatric evaluations prepared for purposes of proceedings concerning competency to stand trial were public records subject to disclosure. And that's State v. Hall, 2001, Ohio 4059. I haven't had the opportunity to read that. I'm just trying to.
The only thing I can say, Your Honor, is that was just added to the statute, I believe, in 2021.
Okay. Interesting. All right, if nobody has anything else, I'll go ahead.
Just perhaps, and again, we're doing this all on the fly, essentially, because this issue was just raised. But I think if the court recalls on August 26th, I did mention in sidebar, because of the complexities of this case, that we may be filing a motion in this regard. So I don't know what council's gonna say, because we have not spoken with council, just for the record. So this is brand new to us as well. We know that the court is doing some research. Perhaps we can adjourn at this point in time, and flush this issue out, quite frankly, because the way that we're seeing it, we want to have time to research this issue now in further detail. Had no idea that it was going to be raised. I just made the argument last time we were here because of the nature of those reports and the testimony that may come out for an incompetent defendant at the time. So I'm just trying to be fair and come up with a compromise here, because if counsel's going to make this argument, we've never heard it, we'd like to have the opportunity to brief the issue as well, and then reconvene. And finally, Your Honor, just for the record, it is our position that this is not even right at this time anyway. Until the maximum statutory period has expired, that's when the issue of tolling becomes right. And we have made that argument, we have filed a motion to stay in that regard, and it's still, we were here to have it because of the availability of the doctors, not even anticipating that this issue would even come up.
Yeah, and you know, I had held the state's motion in abeyance for really two reasons. Is because the history of this defendant having been previously restored to competency in such a short period of time led me to believe that once he was on medications, like most of the defendants that I send with schizophrenia, once they're on particularly injections, become competent within a relatively short period of time, and believed that it was likely to be moot. Now, then many other things happened that were concerning to this court that we were notified of, and that's when I started issuing orders asking for additional updates and such. And it was also concerning that the amount of time that had passed between when he was admitted to when we were notified was initially concerning, but again, I held it in abeyance considering how quickly he was restored last time, when even out in the community. So at this point, though, I have to consider that treatment might be different if they know the time frame that they have. I don't know that. I'd have to. It's one question for the doctors. Is it different? Is your approach different if the date is October 22nd versus some other date?
If I may, Your Honor, with all due respect, if come October 22nd, their finding is that he's not competent, not restorable, he's not released from the hospital at that time. He'll remain there, and they will continue to work with him and provide updates, and when they determine that he is competent, they will be able to bring charges at that point in time.
No, I understand, but again, you know, I've read these cases. I read these cases. I read the State v. Cell that everybody relies on. I read Barker. I read Wisconsin cases. Included in there is a balancing of many different rights, including Wisconsin in particular had a Marcy's Law. They actually call theirs Marcy's Law as well. There's an interest in, first of all, there's a due process right for the defendant in regards to speedy trial, but even if you're not pressing that, there is a right of the state for adjudication of these matters within a time frame where witnesses are available and such. And so I have to balance that. And so I don't think that any unnecessary delay is appropriate. Go ahead.
Thank you, Judge. Your Honor, this hearing's been planned for weeks. And we were contacted by our bailiff earlier this week that someone at the facility who was maybe a supervisor of other people wanted to join the Zoom link. So plans were being made at Twin Valley to adjust and for people to participate in whatever. And it's today that we now hear they're objecting to the public nature of this hearing. I have to wonder, and I don't know the answer to this, but I have to wonder if the facility has ever objected to the public nature of any other proceeding that they've been involved in. Whether there's cameras here today or not makes no difference, because Courtrooms are public all day, every day, all trials, every hearing, no matter what.
All right,
And so that's one point. I apologize, Judge.
go ahead.
But the other point I have is this. How on earth is this issue not right now? I keep hearing this argument from the defense that we have to wait until the time expires to then talk about tolling. That is immensely and utterly unfair to the state of Ohio, this community, and the victims in this case. Everybody should know how long the state has under the year that we have to restore Delonte Hardy. And we've been asking since April. We respectfully ask that this question be answered today. I don't think these doctors are necessary because we have transcripts saying Delonte Hardy refused medication since November. At some point, this needs to be dealt with, and he needs to be forced, and he has been since this court dealt with this in March. But this issue needs to be resolved. Thank you.
Yeah. And I'll also just note for the record that once Twin Valley, and I think you probably, did you include it as one of your exhibits? The most recent updated report?
I included exhibits up to the July 21st report. That's the one, that's State's Exhibit 8. I did not include any others past that for reasons that I can illuminate at closing argument, whatever, but I didn't include the most recent reports.
Okay, just so we all are on the same page and it's on the record.
Sure.
There was a most recent maximum expiration report that was on August
29th, I think it was.
Well, there's the 25th one that we received, and then I ordered additional questions that was, and then they responded on August 29th, in which we explained to them that at the very latest that at least both parties agree on, the actual date is October 22nd, and they did state that that there had been a change in medication, that they believe that there's a possibility he could be restored to competence based upon this change in medication. So I want to make sure that that's on the record and we can make that a part of the record because it needs to be. But I think at this point I'm going to allow counsel from Twin Valley, you can ask counsel from Twin Valley, both of you can ask questions regarding the open courtroom issue, okay? Twin Valley, can you hear me? Okay. All right, Counselor, can you please state your name one more time?
Mallets.
I'm sorry, say it again?
Naomi Mallets.
One more time for me. There's a lot of feedback right now. I'm not sure if you can adjust your...
Naomi Mallets. Can you hear me?
There's just a lot of...
Judge, I think Dr. Hendrickson needs to mute.
Oh, is Dr. Hendrickson also have his own... Is he separate?
We are in the same room.
Okay, can you have him mute then?
It's just the one computer. That's it. She's asking if I'm coming.
Oh, no, it's one computer.
It was clear before, there's a lot of static.
Still staticky?
It's better.
Better.
Counselor, can you please state your name and spell it for the record?
Naomi Mallets, Naomi
All right. So I reviewed the statute regarding the sealing of the psychological reports on the record. However, there is a competing issue regarding the right of the public to open courtrooms. Have you, or do you have any case law that addresses those two competing interests? Or specifically, what, if there's an interpretation regarding sealing of the psychological reports versus discussing them in a courtroom, which is always open to the public? Do you have any case law or any other precedent to point to?
Well, I point to the Ohio Revised Code 2945.371H, where these reports are issued to the court. They're not subject to public inspection by law. And so the concern of having our forensic evaluator testify to matters that are in a confidential report in a public hearing raises concerns from a legal
And so I reviewed that as well.
and to maintain the integrity of this process.
Okay. I reviewed that section as well, and it's specific to the reports, but when you said have your doctors testify in a public hearing, anytime that they do testify, it is public. All courtrooms in the state of Ohio are public. So I think while we were discussing this, one of the questions that the state has, and the defense had pointed out that this is a change in the law from 2021. The statute did not include this prior. Have your doctors testified in any other courtrooms regarding competency since 2021, and have you made any other objections?
It is not usual for our physicians to testify in the public hearing.
It's not a public, so again, it's not, you're calling it a public hearing. All courtrooms are public, whether or not there's another attorney just watching and learning in the back of the courtroom, it's open to the public. So the point is that anybody walking in to these open courtrooms, it is a public courtroom and could hear the testimony, because they're all open. I've not had the occasion in which any counsel from Twin Valley or any other medical facility has asked for a closed courtroom where the court would specifically not permit members of the public, even attorneys or law students, or just general members of the public that were waiting for their cases to be heard, to be in the back. The fact that I understand it might be concerning that you have cameras pointed at you, I certainly understand that, but where is the line drawn, and have you drawn that before? Have you asked for closed hearings before?
I haven't had this situation arise before, to my knowledge.
Okay. But you have had your doctors testify regarding competency hearings in Ohio courts before, and you don't know if, particularly you're on Zoom, who else is in the back of the courtroom.
Typically, when doctors testify, either they're subpoenaed, there's consent involved, and so none of those things occurred here, which is why it's a little unusual. We respectfully ask the court for the opportunity to brief it. We're happy to cooperate just within the confines of the law.
Okay. So for the record, none of your doctors were subpoenaed in any of the court hearings for this case previously, and I've never had the need nor the occasion to do a court order or a subpoena for any of the doctors. Actually, we scheduled this based upon your doctor's availability, and it's just being brought up now. Are you saying that you are not permitting your doctor to testify at this time?
Raising the concern, our doctors, the court did not issue a formal hearing notice in this manner. We were made aware of it just within the last day or so.
We picked this again. So there was an issue where the hearing was not docketed just based upon an accident, but we actually picked this specific date due to your doctor's vacation schedule. So we had conferred with that doctor at least a couple weeks ago. So the fact that you didn't have notice of it is not by any of the parties or this court's doing. I just want to make that clear for the record, that we scheduled it around not only defense counsel, state, but mostly actually this doctor's availability.
You've asked for two doctors' testimony, Your Honor. One is the forensic examiner, one is the treating physician.
And this-
The treating, I will just respectfully request, we are concerned to comply with the law.
All right, do you have any follow-up questions?
I have no questions. The only law they pointed to is the statute that this court's already considered, and I think we can proceed with the hearing.
Our physicians are also concerned that they're bound by their ethical obligations and concerned about professional licensure.
I'll just note for the record, Judge, one of these doctors is the same doctor who testified on March 31st. Over Zoom, in this same courtroom, nothing was said, no objections were made. I don't recall that. I don't know if the court recalls that. With respect to counsel, I've never met you, I've never seen you. And so, again, this is new.
This is the first time it's been brought up, as it relates to the doctor's issues in testifying. And I can't recall if, not that it matters, because open public courtroom is the same whether or not there's cameras here or not. I don't care. So there was no objection from Twin Valley previously, but does the defense have any questions just based upon this particular issue?
Your Honor, we're not a party to this case. We're not
I understand.
objecting. We're raising a concern.
I understand.
On the quick informal notice we received about having two physicians testify.
Your Honor, if I may. First, I would just note for the record, Your Honor, I think the confusion here is that normally when I've had doctors testify, it's concerning a competency hearing or restoration hearing. This is a case of first impression. I think we can all acknowledge that here. The only case in Ohio that I'm aware of that addressed some of this issue, tolling issue, is the Burger case.
Well, the tolling is a completely separate issue from the open courtroom issue. The tolling issue is one of first impression just based upon...
I'm sorry, the tolling.
The tolling issue is one of first impression based upon the circumstances. The only reason why this is a first impression is because it's never been raised before, even though the circumstances have existed before.
Regardless, I think, and I don't represent the doctors here,
I know.
and I have not had conversations with the doctors here. But I believe that overall, if the parties, not the parties, but the doctors' council want to brief this issue, we raised it preliminarily at the sidebar last time. I think that in fundamental fairness
Your Honor, you're cutting out. I apologize.
fundamental fairness requires us to brief the issue. That's all. That's why I said it's a case of first impression. I don't know of any other case in this courthouse or this courtroom over the last 29 or so years that where you had a tolling issue like this, or you had doctors come in hearings other than competency or restoration. That's all my point is, Your Honor. I think that we're certainly still within the statutory parameters, the time limits of 1 year. We would have the opportunity to brief it and come back and the court makes a decision.
I think the most important thing, and again, there can be some factual inquiry here that is not pervasive towards the specific treatment or the specific instances. Specifically, as of right now, is he still taking medications as prescribed? When was the first date that he refused medications? Did they review the prior, and they did review because they put it in their own reports, but I think you have questions regarding the scope of treatment, what constitutes treatment generally. Is that accurate?
Yes, but I also believe that that is what the doctors also have a concern of testifying about, is the extent of the treatment and their procedures at Twin Valley. And while I recognize that they didn't file anything, and again, I can't speak for them, I think this is something that we do need to brief to see whether it should be subject to a public courtroom or not, or whether it should be closed, because of the sensitive nature of the information that will be elicited from any doctors.
This is what I'm gonna do. It's only 2:15. I'm gonna take a break. I'm gonna go back and see if there's anything that we can find on point. We are all here. If we can get this done today, I think it would be prudent to do so. I'm going to look, I know that it was a new statute. I'm going to see if there's any balancing factors. I'd like the council to do so. I'm here till 5. So let's just take a short break and see if we can't get this issue resolved and move on, okay? I'm going to put everybody in the waiting room. You can exit the courtroom. Be seated in your office. We're done.
I'll turn the volume down a little, I think it'll resolve the issue.
the end, and if it's just switching places, if you're swapping out, like,
Yeah, I mean, like,
yeah. I mean, if it's just you two swapping out, it's fine, but if you're getting gear and coming in and out with gear, that's distracting, sorry. Allowed to transcribe. Did you hit the transcribe button? Where did this come from? Yeah. I did this the last time too.
And I didn't. Get anything.
I don't know. It only started since the last time. Be seated. Where's, did you guys see?
They were in the jury room.
Oh.
Do you want me to?
No, I see.
Oh.
Okay. No, it's not. No, I don't know if somebody else is.
That's what I think. Somebody else is.
But usually it doesn't allow them to.
Unless you're okay.
I think so.
Kevin left.
I don't know.
Russ will be here in 1 second.
You everybody? Okay, Ms. Mallix, are you there? See, somebody keeps doing this. I don't know how.
I am here.
I can't
Can you hear me?
Yes. Why it's doing that. Okay. All right. Back on the record. So I reviewed as much as I could. I couldn't find any case law quite on point at all, and you can all share if you found anything. But 2945.371 addresses evaluations and reports of the defendant's mental condition. It is a newer statute, and so it may, in fact, be one of first impression unless you all have found some case law. The report shall not be open to public inspection. And then there's some rules about whether or not it can be disclosed for good cause, providing access to the report by another party. So there's some rules regarding that. However, it's in juxtaposition to 2945.37, where ultimately the issue of competency is going to be litigated in a courtroom, whether it's by stipulation, which oftentimes it is, which it was previously in this case, where everybody stipulated to the findings in the report, or if it's contested, it results in litigation. And so it says the court shall hold a hearing on this issue, and that is a mandate to the court to hold a hearing, and it doesn't say anything about a closed courtroom. And then in subsection E, so that was subsection B, in subsection E it says, the prosecutor and defense counsel may submit evidence on the issue of the defendant's competence to stand trial. A written report of the evaluation of the defendant may be admitted into evidence at the hearing by stipulation, but if either the prosecution or the defense objects to its admission, the report may be admitted under sections 2317.36 to 2317.38. Now, 2317.36 admissible reports essentially is a written report finding of facts prepared by an expert who is not a party, which this applies, and it further states that the persons acting either in concert or by themselves contributing to the report shall, insofar as the same is relevant, be admissible when testified to by the person. Then I'll note that in every single report that I've seen, including Dr. Hendrickson's report on 825 on page 3, wherein the doctor explains the limitations and the rules regarding their discussion with the person that they're examining. And so I'll just read from the doctor's report, which is standard practice in any of these reports. Before proceeding with the interview, I provided Mr. Hardy with a verbal explanation of the nature and general purposes of this evaluation, as well as the limits on its confidentiality. He was informed the court had requested an opinion about his current mental condition, his capacity to understand the legal proceedings against him, and his capacity to assist counsel in his own defense. He was advised on his right to consult with counsel to help him decide if he wished to withhold any information during the examination. He was informed that he did not need to answer any question for which he thought his answer might prejudice his case. He was told that based upon the evaluation, I would prepare a report, copies of which would be distributed to the judge, and with permission of the court to his attorney and the prosecuting attorney. He was advised, if called to testify by the court, this report would also form the basis of my testimony. Mr. Hardy indicated he understood this and agreed to participate in the examination. So these notifications to the examinee are routinely, and I've never seen them not included, where Mr. Hardy was advised by Mr. Hendrickson that if he was called to testify, the report would form the basis for his testimony. Now, the only thing that I could find was State v. Hall, which is a 2001 case, which defense pointed out the statute had changed since then, but there are other points in the statute that are relevant that still stand. As it relates, Ms. Mollitz, to your concern regarding his ethics, and he's been engaged by the courts to provide an expert opinion, to provide a psychological opinion, and that is, and even by his own standard practices, he was advised the examinee of the limitations of the confidentiality. Furthermore, it cites Higher Revised Code 2317.02B1, which states, moreover, the physician-patient privilege attaches only when a person consulted a doctor for treatment or diagnosis, and does not extend to the situation when the doctorate is hired to render opinion for purposes of litigation. So, I mean, again, this is the first time I've ever heard any counsel from any mental health facility which a criminal defendant has.
I'm sorry.
This is, might be one of first impression. This is the first time, because we routinely engage and have defendants sent to these facilities for the purposes of determining competency for a criminal case, in which time each of the examiners must report and advise the defendant that this is for the purposes of court proceedings, that the statements can be used in court proceedings, well, not in the criminal substantive aspect of it, but that the confidentiality is limited in that the doctor can be called to testify to their discussions and their engagement and the opinions to the court in a hearing that is required to be held by this court. And so, it's hard to limit this doctor's testimony either on an ethical basis, because the ethics in black and white exclude that he's not violating any doctor-patient confidentiality by testifying in a hearing. And the hearing, specifically discuss admissible reports, 2317.36, insofar as is relevant. And so that's why maybe we've never had an issue particularly already happening in this case where there's testimony by this doctor not objected to because it's routine. And it's part of their duty as being engaged by this court to conduct mental health evaluations and testify to those evaluations if necessary. The legislature in 2021 had the opportunity, if it wanted to also amend the court's duty to hold a hearing stating that any hearings on competency would be closed to the public, the same as the sealing, but they did not. I can't find any other case law that's on point. I've never had an objection to this prior. I think, when we first started this case from the first hearing, I said, I'm not going to treat this case any differently, and I don't treat any case any differently, no matter who's in the courtroom. I don't care if it's a camera or somebody off the street that came in. The cases would be treated the same, and I think that the concern here is possibly that, but there was no concern, and I've never had a concern from North Coast, Twin Valley, for hearings ever before, for their doctors testifying. Has anybody found anything else to the contrary? Or any case law that's addressed this issue?
No, nothing to the contrary. In fact, the cases I found, I actually sent 2 of them to the court and defense counsel, State versus Drummond and State versus McAlpin, which stand for the ideas that closing the courtroom.
I'm sorry,
Yeah,
it's
no.
down. Can you turn your volume down, please?
Okay, thank you.
I think she did.
I'm not sure who you sent that to. I don't know.
I sent that to your bailiff. So my apologies. State versus Drummond, State versus McAlpin.
Can you give me the sites on that?
Yes. State versus Drummond is 111 Ohio State 3rd 14, 2006 Ohio 5084. And McAlpin is 169 Ohio State 3rd 279, 2022 Ohio 1567. These stand for the idea, Judge, that closing a courtroom can itself be structural error to a defendant's detriment, and regardless of whether a defendant objects or wants the closure, it can be raised on appeal as plain error. So I just put those out there. The state agrees with the court's assessment of the statutes. There's no statute that specifically speaks to the closure of courtrooms during psych hearings that are contemplated by the statute, in fact, required by the statute. So the state is ready to proceed. Thank you.
So statement versus McAlpin would have been after the change in the statute?
It is after the change, although admittedly that case does not talk about the closure of a courtroom for a psych hearing. It talks about closure of courtrooms more generally. In fact, let me,
Potentially that's, yeah. We all have.
So this was in the reverse where the closure of the courtroom was for the benefit of possibly a state's witness?
I think it was.
Okay. And the defendant didn't object at the time and then it was up on appeal?
I believe so.
Yeah. And again, that was 2022. Was this based upon, when it says closure of the courtroom, was this based upon the old Supreme Court rules regarding the court's, at the time, the court's ability to allow the witnesses or the victims to determine whether or not they want to be reported?
This definitely would have occurred under the old rules for the Court of Common Pleas in this county.
Okay.
Yeah.
And those are no longer here. So not only does the state not have the ability to do that, close the courtroom to recording or video any longer pursuant to the Supreme Court rules, but again, I don't see anything in the statute that allows me to close the courtroom. I understand that the written report, and it appears to me that this is limited because not every mental health evaluation, which we do very, very many of them, sometimes it feels like weekly, where I request reports for defendants and they're prepared, either result in transfer to mental health docket, result in transfer or admission into specific specialty dockets, or there's a finding where they're not eligible for transfer and are not necessarily, I understand why those reports would not be open to the public. But when it comes to the point where we're determining competency and the court is required to hold a hearing, in any of those other cases, I've never, usually there's a stipulation when it comes to a defendant being eligible for a mental health court or allowed into intervention in lieu of conviction, which does go over mental health history. It's usually stipulated to, oftentimes, if it is contested, it's not on that basis, but it's never been requested that the courtroom be closed. And that's why I think it's an issue of first impression, because I think it's related to the report unless and until there's a litigation regarding it, which requires a court hearing. And in that respect, they did not change the statute. Closing a courtroom in the state of Ohio used to have a balancing test, and it, for me to expel but now I'm not sure, there's no guidance onto the statute. There's no statutory rule and there's no local rule. We can review the local rule as it's written because it was just changed this past year. Like, I think this year, actually. Did you guys find, did the defense find anything?
Your Honor, at this time, we understand the counsel's position on behalf of the doctors. We would just defer to their argument.
But be that it is may, so I'll allow Ms. Mallett, you can weigh in. The specific four corners of the engagement of your facility and the fact that it's paid by the state and engaged for the specific purpose is for the preparation of these reports and to testify to them in court.
Yeah, yes, Your Honor, and we are not asking that, we are just asking for the process to be followed in the proper manner, and with respect to the forensic examiner, that process is governed under a different confidentiality statute than the treating physician. So while, there is a case, Turkey Oiler, which does reinforce the strength of the physician-patient privilege, that does not apply to the forensic examiner, I acknowledge, but it does apply to the treating physician.
So the treating physician is engaged.
Dr. Duntanetti.
Dr. Duntanetti is engaged and created reports. I mean, there's a...
He is not the forensic, Your Honor. I'll just make that, he is not the forensic.
Let me just finish the thought here, is that, again, the only reason why your court is engaged is not for the purposes, it's specifically they were sent there for competency restoration for the purposes of this case. I believe Dr. Duntanetti, just look at my notes here, submitted a report. Dr. Duntanetti had completed an independent evaluation for forced meds and submitted, and Dr. Savageau as well. And it specifically relates to, in admissible reports, it contemplates this, containing conclusions resulting wholly or partly from written information furnished by the cooperation of several persons acting for a common purpose, shall, insofar as the same is relevant, be admissible. So all of the reports, all of the interactions between staff at your facility have all been included in the final report that's been submitted here. So it's a compilation, and that's specifically what Twin Valley has been engaged in. I've again, not had this objection come up before.
Your Honor, if I may, the reports and the records are different than the testimony itself, and so we would just ask this court, without, we're not aware of the scope or the limit of this testimony. We do believe that Turkey Oiler applies to the treating
What's the name of that? Can you give me the citation and the name of the case, please?
Turk v. Oiler, T-U-R-K, excuse me, V-O-I-L-E-R. Citation is 732 F sub 2D 758.
So,
and Your Honor, we would ask the court to consider having our forensic examiner, if the testimony is, we'd ask that they be subpoenaed or court ordered to testify with direction as to the scope of that testimony.
all right. So it sounds like Turk v. Oiler was there's no state in front of it. There's no United States in front of it. That's a civil case, federal?
It is.
Okay. So again, this is a criminal case. Again,
yes, but the physician-patient privilege still applies to a treating physician, Your Honor. We are just trying to
Again,
That's when
so
it comes
Ohio
to
Revised
the-
Code, I'll repeat it. The Ohio Revised Code 2317.02. So yes, that is, but it does not apply when there's, you're hired for rendering an opinion for purposes of litigation. And again, this is specifically for the purpose. I mean, you're basically asking this court to undo all the purposes of which we engage Twin Valley for competency, treatment, restoration, and specifically, I mean, there's really no need if we can't get you in here to testify, there's no need to engage those services because I have to hold a hearing. It is mandated by the court, and it's also advised that the examiner, if called to testify in court, it would form the basis of the testimony. And included in that is Dr. Dontinetti's engagement with the client, along with even staff there. And so this this
Your
attorney,
Honor, Dr. Dontinetti was not the one retained to provide the opinion. It was Dr. Hendrickson. I believe the information you are seeking is in his report, and he can testify today.
that's fine. So the limitations of this report are, the limitations of this testimony is simply to establish, and here was going to be my next point, because there's no reason to do something that's unnecessary, and that's where balancing always comes into,
I'm sorry, that's where balancing.
always comes into play here. The limitations of what is necessary to be heard here is essentially as it relates to tolling, the type of treatment, whether it was educational regarding, because there's two factors here. There's not only the competency to understand the court process, the nature and charges, and in fact, that one piece of it where there is education regarding understanding the legal process, in the previous reports and the reports up to this, that has always been that he was competent and he did understand those. The only thing that was interfering was the only thing that the findings were regarding his ability to assist counsel due to some the effects of his schizophrenia. So there's two components to that, and the reports discuss his ability to understand the role of the judge, the role of the defense, the role of the state, what a plea bargain is, what a trial is. He understood all of that, and so that's one component to rehabilitation, but that was never his issue. His issue was his schizophrenia and the delusional issues that contributed to his thought blocking, and we'll get into that, but the issue here is what type of treatment was he receiving, and I think that the state wants to ask some questions regarding timing, and I think that the defense wants to ask some questions regarding the nature of the treatment. So that's what it's going to be essentially limited to, okay? All right, so if you could put Dr. Hendrickson.
Okay, just one moment. Let me get just one moment. I'm getting the power cord.
Your Honor, if I may,
Yes.
are we questioning the doctor now, or?
Yes.
What do we, okay. So, just as a point of clarification, last time we were here in August 26th of this year, on the status hearing, on the record, the court had some concern about the tolling event, and I believe that's why we're here under the state's motion.
Yes.
And one of the issues that you brought up, that the court, I believe, brought up, I don't believe it was the state, but it was about this alleged ingestion of substances. At that time, I approached and asked the court to approach. We talked about sidebar. I objected to it for the very reason that we didn't want to prejudice the proceedings whatsoever. The court wanted to have more information on that particular issue. The court ordered the doctors to go out and get all the investigative reports, either internally or externally. That has been done. So my question, my clarification question here is, are we addressing that issue? Because the doctor completely opined that based on this investigation from the local police department there, based on their internal investigation, that they changed the protocols, as the court mentioned earlier, but they found no quantitative or tangible evidence that Mr. Hardy ingested any illicit substance or any other medication from any other patient. So what I'm asking this court is for clarification. Are we addressing that particular issue where it has been cleared up through the reports and investigation, or are we just addressing the tolling issue prior to March 31st, 2025?
Okay. So that was a concern of this court, and I thought it, well, let me ask the state. You've reviewed what was submitted. Are you satisfied with that?
Your Honor, like I said at the beginning of this hearing, the state is prepared to proceed on the pending motion, the motion that was filed on April 4th.
Okay.
We did not file anything with regard to, or seeking any tolling situation based on anything after the time frame we've identified.
Okay.
And so I think we'd like to keep the record clean with regard to what we're seeking.
Not an issue then.
So just so that we're clear, the court's not going to ask questions concerning this ingestion where it's been found baseless.
I'm not going to ask any questions about it. The state is not seeking any tolling regarding that issue. So it's irrelevant for the state's motion.
Thank you.
Okay. This is the state's motion, so I'll allow you to begin.
Thank you. Should I just remain seated, Judge?
It's however you feel. Yeah, he can't see you, so it might be
Yeah,
better
let's
that
do
he
that.
can see you.
Okay. Doctor, my name is Kevin Filiatro, Assistant Prosecutor. Can you see and hear me?
Uh-oh. You're muted.
Yeah, but I'm mute.
And Dr. Hendrickson, I'm also just,
Hi, can you hear me now? Sorry.
there's some feedback again.
Still there?
Yes. Perhaps if you lower your volume.
Still there?
Seems to be still there, yeah.
Your Honor, just to clarify, it was my understanding that their legal counsel was indicating that they did not want Dr. Donnetti to testify. I just wanted to clarify whether he will or will not be testifying so we know whether to focus our questions just on Dr. Hendrickson.
So again, this is, you would like to have, who was requesting Dr. Donnetti?
The defense requested both.
Do you still intend to question Dr. Donnetti?
Yes.
Yes, Your Honor.
All right, and I'm assuming that you do not agree with Twin Valley's counsel regarding her position that these are treating physicians, not subject.
Your Honor, we can't comment as to their licensure and what their requirements are. We just know that we would like Dr. Donnetti to testify.
Okay. But again, I'll state again that the statute is clear regarding the, essentially the common purpose of several persons acting in common purpose shall, insofar as the same is relevant, be admissible when testifying by the person or one of the other persons making such report. So again, Dr. Donnetti had earlier filed reports regarding forced medication, So his own report regarding forced medication that was submitted is extremely relevant because that's exactly when the forced medication timing occurred. So he's already submitted a report in this case and therefore cannot even conceivably, which I don't agree with their analysis regarding doctors engaged for these purposes that are somehow classified as treating physicians not subject to the same rules as doctors that are called to testify in cases, and he already submitted a report, much like Dr. Hendrickson. Dr. Hendrickson, I'm just going to have you raise your right hand. I'm going to swear you in.
He needs to be unmuted for this.
Yeah, if you could unmute.
So I'm having some battery issues also. We've been having to pull it in and out because that is also something that's going on right now, just an FYI. Is everybody on that side still having feedback?
Yes, there's a lot of feedback. If you have another device, if you have the Zoom number, you can call in from another device. You can call in from a phone and keep yourself muted on here, and we can still see you.
We can probably find another computer. I just don't have one readily available, but I can go try to find one.
You can also, in the email, there should be a call-in number too. You can use the phone to call in and just mute yourself as well, the phone behind you, if you have the number.
Okay. Still getting that feedback?
Yes.
I'll leave it as well. Can you all hear me now?
Yes, much better.
Okay, great. Here, I'm gonna turn my volume up just so I can hear you guys. Okay.
All right, Dr. Henderson, if you could please raise your right hand. Do you swear that your testimony will be the truth, the whole truth, and nothing but the truth, as you shall answer unto God?
I do.
Go ahead.
Thank you, Judge. All right, Doctor, are you familiar with a report dated March 18th, 2025. And I think there were two that day. The first page of that, page 1 of 26, has at the top status report regarding competency restoration pursuant to ORC 2945.38F.
I believe that was my first evaluation that I did. I just want to make sure I have that. Yes, March 14th, 2025, that was my initial evaluation that I completed for Mr. Hardy with regards to his competency.
Right, and is this the report that was the basis for, on the same date, a request being sent to this court asking for the ability to use force to administer medications to Mr. Hardy?
March 14th?
March 18th, the date on the letter of
Okay.
Dr. Hendrickson's report. March 18th, the date of the letter accompanying the application to authorize involuntary psychotropic medications.
Okay.
I believe they were sent around the same time. I obviously wasn't offering any opinions in that report related to medication. I do believe in that report I made note that Dr. Dontanetti was likely going to be filing for a force med order at that time or around that time. So yes, that would have been right around the same time.
Okay, and so, why is it that Dr. Dontanetti would have to file for that ability to have force to administer medications?
Well, I'm not a medical doctor, and so the lane that I stay in with regards to my assessment is specifically with Mr. Hardy's competency to proceed, competency to stand trial, and really understanding the nature and objective of the proceedings and his ability to assist in his defense.
All right, if Dr. Henderson, if you could just go a little bit slower for our court reporter.
Oh, sorry. So the nature of my evaluation was directly related to Mr. Hardy's competency to stand trial. What that means on my end is his understanding of the nature and objective of the proceedings and his ability to assist in his defense.
Okay, and I don't mean to cut you off, but I appreciate that. The question here from me, when did Delonte Hardy stop taking his medications? In November of 2024.
I don't have that readily available since I'm not his treatment provider. I don't have that data available to me right now.
Would Dr. Dontanetti have that information available?
He would have to check his records. Yes, he would have to look through those records.
Okay, my last question for you. Are you familiar with a hearing this court held on March 31st of this year regarding the forced medications issue?
I believe I was made aware of that hearing in passing, yes.
Okay, were you present over Zoom to observe that?
No, I was not at that hearing.
Okay, so when you do your report, do you review the treatment records or do you speak with Dr. Dontanetti?
Yes, I reach out to the treatment team. I get their report with regards to how the patient is doing. I review, recent relevant progress notes related to mental status, how they're doing in group, individual programming with regards to competency material, those types of things, yes.
Okay, so last couple questions for you. So having reviewed that information prior to writing your report on March 14th of this year, would you agree with, Dr. Dontanetti testified in this courtroom over Zoom. I'm looking at State's Exhibit 6, page 5. Dr. Dontanetti testified with regard to Mr. Hardy. He took medications on 2 different occasions, but not more than a few days each time. The court asked the next question. Did there come a point where he refused the medications? Doctor testified. He refused the medications. The court asked, and do you have a time frame when he started to refuse to take the medications? The doctor testified. Within a week of starting the medication, he complained of not feeling good on the medications, so he stopped taking them. Next page, page 6. The court asked, do you know approximately when that was?
Hold on, just let him go through it and then ask the question.
The court
Are
asked,
you referring, I'm sorry, are you referring to my March, evaluation? Are you directly reading from that March?
no.
So he's asked, so essentially, he's reading from Dr. Dontonetti's testimony, and he's explaining to you what Dr. Dontonetti's testimony was, and then he's gonna ask you some questions about Dr. Dontonetti's testimony related to your treatment and knowledge, okay?
I'm prefacing a question,
Okay.
all right? The next thing doctor testified, he came here in October. This was initially in October, the first medication, and then the second one was in the beginning of November. So, my question for you is, the doctor testified, he took medications twice and then stopped. Does that coincide with your understanding prior to writing your report on March 18th of this year?
Again, I don't have that March report in front of me. I do believe that in that report, I made note of, hey, he had demonstrated intermittent medication compliance with his treatment, with the medication with his attending psychiatrist. I'd have to pull that report up. I have my most recent report, which was from August of 2025.
All right. So, look, if this court's interested to know the dates on which Mr. Hardy took medications, is that a question we should ask Dr. Dontonetti?
Dr. Dontonetti would be better equipped to answer questions related to medications, specifically because he is the treatment provider.
Okay. With regard to your report on March 18th, was it true and accurate when you submitted it to this court?
With regards to my opinions?
Everything in it?
In the report?
Yes.
Yes, I'd like to, can I pull that report up just briefly? Yes, I'd say it's accurate, but yes, my report was accurate based on my meeting with Mr. Hardy at that time. I don't have those specific dates readily available again, like I have my most recent report here. But at that time, he was evidencing, if I recall correctly, psychotic symptoms that precluded his understanding of nature and objective proceedings and his ability to assist in his defense.
Right, and so the various times that you write in that report detailing how Delonte Hardy was refusing medications, you have no reason to doubt that now. You wrote it back then, right? It was true then, it's true now?
Yes, yes, yes.
All right, nothing further.
Go ahead, thank you.
Hi, Dr. Hendrickson, can you hear me?
Yes, hi.
Okay. I'm going to ask you a couple questions first to clarify. What is your role at COBH?
At COBH, as it pertains to Mr. Hardy, I was assigned to do his competency to stand trial evaluations. So the forensic examiner that works at the hospital but is asked to evaluate Mr. Hardy's psycholegal capacity. So again, his understanding of the nature and objective proceedings and his ability to assist in his defense.
Okay, and I just want to clarify a couple things because we go back and forth. We keep using the words Twin Valley or Central Ohio Behavioral Health. So if I'm correct, it just changed the name Central Ohio Behavioral Health in May of 2024, correct?
That sounds about right. Yeah, I know we moved over here, and it was around that same time, so 2024, yeah.
Okay, but it was called Twin Valley all the way back since 1977, right?
Yes.
Okay, and just to clarify what that is, it's a regional state hospital, correct?
Yes.
And it's run by the Department of Mental Health and Addiction Services?
Yes, so Twin Valley, now Central Ohio Behavioral Healthcare, as well as Moritz, so Timothy B. Moritz Maximum Forensic Security Center.
All right, and I want to clarify a couple of things in there. So there's 6 regional state hospitals, but the Twin Valley or the Merritt Center is the only maximum security regional state hospital, correct?
Yes, that's correct.
Okay, so even though you're Central Ohio, you sometimes get people outside of Central Ohio because all the other state hospitals are secure, but not maximum security, correct?
That's correct.
So you'll sometimes get people from other regions, for example, from the Cleveland area.
Yes.
Okay. And out of the 6 hospitals, that's the only one that's maximum security.
Yes, that's our maximum security unit for the state of Ohio, yes.
Okay. And you said that you treat forensic patients. About 90% of your patients are forensic patients at COBH?
So let me clarify, in terms of my role here at the hospital. I work on a competency forensic unit that deals with competency restoration. That deals with treatment. That's in our main hospital, COBH. However, I'm also asked to do impartial objective evaluations of patients' competency that I have not done competency restoration work with. And so that would be an example of, again, a patient I haven't done any clinical work with or treatment with, but it's an impartial evaluation.
Okay, thank you very much. I want to talk to you a little bit about restoration treatment. First of all, you're responsible for knowing the timeframes for restoration treatment, correct?
In terms of like what they could be based on the charges?
Correct.
Yes.
Okay. And so for Mr. Hardy, you knew the time frame of 1 year, correct?
Yes, I was informed, yes, based on his charges, in my understanding of the statute, that would be 1 year of restoration.
Okay. And I want to ask you some questions about what's involved in competency restoration. You do, when someone comes to COBH, there's an initial assessment done, correct?
Yes, by the treating psychiatrist. They will sit down and do a comprehensive psychiatric examination upon admission to the hospital.
Okay. And a treatment plan is developed, correct?
Yes.
Okay. And Mr. Hardy would not have just seen just the psychiatrist, but there would have been other team members that he would have interacted with, correct?
Yes, on his treatment team, there's various disciplines. They're interdisciplinary. So you've got nursing, adjunctive therapy, social work. Sometimes there'll be psychologists that will work with patients as well. So yes, it's not just it's not just the psychiatrist that's sitting down and meeting with the patient regularly as part of that competency restoration treatment. Okay, and
I want to talk a little bit more about that. So a patient would meet with the psychiatrist. They would also meet with these social workers or therapists, attend classes, things like that.
Yep, groups specifically for competency-related things, competency material, understanding various roles in the courtroom, things along those lines.
And that's all part of the course of treatment to restore someone to competency.
Yes, here at the hospital.
And at the hospital, medication is often part of competency restoration, correct?
Yes.
Okay. But it's not always part of competency restoration, correct?
We've had patients who are admitted who sometimes might not need medication. And again, I'm not offering medical testimony here, just as someone who works on a competency restoration unit. There's various moving parts with regards to competency restoration. However, medication is a big part for a lot of our patients.
But it's possible when you've written reports that some people have been opined competent, restored to competency, even though they've never taken medication.
Yes.
Okay.
Possible.
I'm sorry, can you repeat that question again?
It's possible that some people he's written a report for have been opined competent, even though they had never received any medication. They've been restored to competency.
Are you talking about persons generally or persons with this diagnosis?
Persons generally.
Okay.
We've had patients admitted to the hospital who, after a period of observation by the treatment team, it's been the treatment teams and specifically the psychiatrist's opinion that medication might not be warranted. And as a result of that and observation of the patient, it's the treatment team's opinion then that the patient might be good to go from a competency perspective. They will then request that evaluation. That might be an example of a patient who might not be on any medication when they're evaluated and are opined competent.
And I want to talk to you specifically about Mr. Hardy's course of treatment as you described it in your report writing. When you wrote the report, you reviewed all the available records, correct?
I went through and reviewed the available records, yes. I talked with his treatment team. And again, just to clarify, what report are we referring to? Because this was just a little unclear to me. I have my report, my most recent report here from August, but I also did a report for him in July as well as a report for him
Yeah,
in
if
March.
you want to pull up your March report, if you have that available, you may do so.
My battery might die, so, let's see. Oh, yeah, that might be. Okay, I have that report pulled up.
Thank you, Doctor. All right, I'm looking at that report. One of the things you reviewed were all the available records to you, correct?
Yes.
And that would have included what charges Mr. Hardy was facing, correct?
Yes.
Dr. Archangela Wood's report, correct?
Yes.
And the fact that she had opined that he was not competent to stand trial, correct?
Yes.
And that he was diagnosed with an unspecified schizophrenia spectrum or other psychotic disorder.
I believe that was the diagnosis she authored. Again, I know that Dr. Songer had met with him as well. I know that he was evidencing psychotic symptoms at the time, or at least he was documented by both of those psychologists to be evidencing psychotic symptoms at the time when they met with him, which led to their opinions about his competency.
Okay, so Dr. Archangela Wood and Dr. Songer both found that he had psychotic symptoms, also was describing severe delusions, correct?
That is correct.
Okay. And did you review also the COBH chart when you were writing this report?
I did.
Okay, and just to be clear, the chart is your internal system that memorializes all aspects of his treatment, correct?
Yes, that is correct.
Okay, and I think you already testified that you consulted with his treatment team as well?
I did, yes.
Okay, and so when you say treatment team, that's not just the prescribing doctor, but also the social workers, therapists, other team members?
Yes, his other treatment team members, making sure I've got this here. So that also might include SAMI counselors, substance abuse and mental illness
I'm
counselors.
sorry, can he repeat?
Can you, sorry, you just went a little bit fast. Can you repeat that for us?
Oh, that also might include substance abuse and mental illness counselors.
In
Looks
fact,
like I had some.
I think you noted that you spoke with Camille Satterwhite, who was his substance abuse and mental illness counselor.
Yes.
Okay. And both Dr. Wood and Dr. Songer reported delusions. That also was confirmed with the SAMI counselor, correct? That they were describing delusions.
The descriptions, I believe, that Ms. Satterwhite noted, yes. Yes, that is correct.
Okay.
Delusional material, signs consistent with delusional material, delusional thought content.
Okay. And in your report, you summarized the course of Mr. Hardy's treatment, correct?
Up to that point, yes. It's focusing on how the psychiatry, looks like here, he'd initially been assigned to work with Dr. Charles Foreman, and was reassigned to Dr. Donnetti in January of 2025.
Let me ask you about that, doctor. Is that unusual to switch doctors? Does that happen sometimes when someone is being treated at COBH?
It can happen for a variety of reasons. I don't recall off the top of my head the reason for that switch. I can't say that there was some change in staffing So it's likely related to some staffing changes that we had down in Maritz. But again, I don't have that data on me right here.
That's fine. And then just for the record, I think you've already testified he was admitted on 10/22, correct? 10/22/2024.
Yes, that is correct.
Okay. And originally, when he was under Dr. Foreman's treatment, he did agree to take some medication, correct?
I believe so. I think there was documentation of intermittent medication compliance. So I'll make sure that I'm getting that right. Yes.
And let me ask you, doctor, with this kind of diagnosis and these delusions, is medication compliance sometimes difficult with people with this kind of diagnosis?
Yes. Generally, individuals with psychotic disorders, such as schizophrenia, one of the areas of concern that treating psychiatrists will report having is issues related to medication compliance, specifically with regards to insight into their mental illness. So insight into their need for treatment to address those symptoms.
Okay, and I want to talk a little bit more about that. So when we're saying insight, tell me, is it fair to say that they don't think they're sick, so they don't think they have to take medication?
That's correct.
So part of this reluctance to take medication is a symptom of their illness.
That's correct.
Okay, and very common with this type of illness.
That's correct.
In fact, so common that doctors have come up with a strategy to try to get medication compliance.
Are you referring to through like a forced medication order?
No, I'm talking to you through like a treatment alliance, trying to talk to them, give them insight into their illness, create a rapport with them, things like that.
Yeah, and again, I'm not a psychiatrist, but psychiatrists, they want to build therapeutic alliances with their patients and build rapport, as you said. And so if they can, and again, this is just based off of my interactions with psychiatrists that I've worked with, they will do that as a means of attempting for the patient to, on their own volition, agree to take medication.
And also, when, in your experience working with psychiatrists, when a patient complains of a side effect, sometimes they might change the medication, correct?
Again, I'm not a psychiatrist, but that is something that I've seen here, in working with psychiatrists here at the hospital.
Okay. And in writing your report, both from your review of Dr. Foreman and Dr. Donetti's records, you noted that they were trying to encourage Mr. Hardy to take his meds, correct?
That is correct.
Okay. They were trying to give him some insight into these delusions that he was experiencing and, convince him that taking meds was a good idea.
There were attempts on the part of his psychiatry treatment team to get him to take medicine, again, just based on my review of those records, yes.
Okay. And I want to talk to you, before you wrote your March report, you met with him on both 313 and 314, correct?
Yes, that's correct.
Okay. And he was describing those same delusions to you, correct?
Yes, at that time, Mr. Hardy presented effectively quite similar to how he presented with both Dr. Songer and Dr. Wood.
And he was cooperative and polite with you during those meetings, correct?
Yes.
And when we're talking about this diagnosis and these delusions he's describing for you, I just want to go over, there's this term malingering, correct? You're familiar with that?
Yes.
That's when someone's faking their mental illness, correct?
Yes.
And as an evaluator, you have ways to check for that, right?
Yes, there's a variety of different avenues that evaluators can go down with regards to assessment of feigning of serious symptoms of mental illness and ultimately malingering, yes.
Okay. And you evaluated Mr. Hardy for this, and you didn't find any evidence of malingering, correct?
No, that would be inconsistent with Mr. Hardy's presentation.
Tell me
Mr.
what
Hardy
you mean.
has, so again, this is based on available evidence. I have Mr. Hardy, his treatment history, his diagnosis history for this goes back to, at least from the records I've reviewed, 2023. at which time I believe families started to report him beginning to evidence some of these, what we think of as persecutory delusional thought content. So this diagnosis goes back quite a ways, at least to, I think it's November of 2023. The nice thing about when we have patients here at the hospital is that we get a lot of eyes on them. And specifically what I mean by that is that we have, interdisciplinary treatment team members that are able to work with that patient on a daily basis. And there weren't any indication, and multiple psychiatrists have met with Mr. Hardy as well. They've been diagnosing him and treating him for a psychotic disorder since he was admitted, or attempting to treat him. And as it stands now, he's currently taking antipsychotic medication prescribed by his psychiatrist. So the totality of that data is not consistent with an individual that might be feigning symptoms of a serious mental illness.
Okay. So in this, people with this diagnosis reluctant to take medication, there's a system, and I think you referenced it already, about that you can apply for these forced or involuntary medications, correct?
Yes, the treating psychiatrist can attempt to obtain a forced medication order, yes.
Okay. And I want to ask you, if you know, doctor, when we're talking about refusing medication, about exactly what that looks like. If their treating doctor says, will you consider taking this? And they say, yeah, I don't really want to. I mean, is that what you're talking about when you say refusing?
Again, I want to be careful not to get outside of my lane here with regards to medication.
Can I see attorneys at sidebar?
You're on your own.
Yeah.
The last question I referenced specifically with APOMO, but the other things I asked about medication were specifically within the report that he wrote.
No, I know. And there's a lot of crossing over. I agree, but he's trying to say, that's not my wheelhouse. So
You want to with our record, we got one chance, so we're trying to get, I don't know what Dr. Patton he's going to testify to. I agree it can be difficult to understand sometimes.
And so, there is in his report, either it's hard to tell if he's adopting everything or he's also lying on himself. It's not necessarily clear, or if he's just reporting what's already in the record to include in his report to the court. So I see how that line is blurred, but it seems that some of these questions are specific to actually prescribing medications and when they should be prescribed and so forth. But there is something to be said about his ability and his job in reviewing his prior treatment, his prior incompetence, prior restoration, and what he was about.
Is it good for not to read maybe not.
Refusing medication, so that's their aim. But when it comes to actual prescribing, he's saying that he can't answer some of these questions. Okay, let's try to be specific. Oh, what just happened?
Tell me when you're ready, Dr. Hendrickson. Are you ready?
I am ready, thank you.
Hi, I'm ready. Just trying to
Thank you.
fix some technical stuff.
When you filed your March report, I believe when you were answering the prosecutor's questions, you indicated that was right around the same time as the involuntary administration of medication request was made, right?
Yes, that's correct.
Okay, and as you've already indicated, you don't make that request, but in fact, the treating psychiatrist makes that, right?
Yes, that's correct.
And I think the reason why, if I understand, is that you don't prescribe the medication, that the treating psychiatrist prescribes medication, right?
Yes, the treatment provider is the psychiatrist. I'm the independent evaluator. I'm tasked with evaluating the patient's competency to proceed.
Okay. And what allows someone to prescribe medication in the state of Ohio?
Objection.
Again, you all have different roles, you work together, so if you're familiar with what you can and cannot do and who you would need to go to for prescription, you can answer. Are you familiar with the licensing requirements to prescribe medications?
I'm sorry, did you, Your Honor, did you ask?
I am muted, sorry. Are you familiar with the licensing requirements to prescribe medications?
No more than a layman.
Okay.
Again,
Do you know if there's procedures at COBH for when to do an application for the involuntary administration of medication?
I believe that we have procedures in place, but again, that would be a question better handled by someone who does that on a regular basis.
Okay. I want to ask you some questions about Mr. Hardy and his diagnosis and not taking medication, okay? It's been described by the prosecution here that he is sabotaging his treatment. In your experience, with patients with this diagnosis refuse to participate in taking medication, is that a symptom of their illness or some diabolical plan?
Generally, when patients, specifically with diagnosis of a psychotic disorder, if they're not taking their medicine, it's because they generally don't believe they need to take the medicine. But again, I'm not a medical provider, but I can talk with you about clinical observations with regards to patients such as that.
Okay. And you noted in your reports that Mr. Hardy was participating in groups and classes, correct?
Let me just double check, because this was from a while ago. I believe he had at that time been going to some of the groups. Yeah, so he had been attending some of the groups on unit.
Okay. And when you did your testing, you noted in your report that he engaged and put in effort for the testing, correct?
Yes, Mr. Hardy put forth good effort over the course of those two interviews. There wasn't any indication that he was feigning effort or putting forth poor effort.
And certainly in your experience, you've seen that, right? Where patients come in and they refuse to participate or work with you at all, correct?
Yes.
But that was not the case with Mr. Hardy?
No. Mr. Hardy, I just want to make sure I don't misquote myself. He was noted to become, he evidenced paranoia and guardedness, which is consistent with someone with
Paranoia
his
and
symptomatology.
Sorry, can you repeat that for our court reporter, please?
At the time of my meeting with him, he was noted to present with guardedness and paranoia, consistent with someone with his symptomatology, consistent with someone diagnosed with a psychotic disorder such as his.
Dr. Hendrickson, in your report, you noted that Mr. Hardy has consistently stated he wanted to be restored to competency, correct?
Yes, that's correct.
Okay. And that's because I believe you noted he wants to present his defense based on his delusional beliefs, correct?
What I can say is that Mr. Hardy has several strategies that he hopes to go over with defense counsel, yes.
Since you have done the administration of medication ordered by this court, Mr. Hardy has taken the medication, correct?
Since that order was put in place, I believe he has taken medication, yes.
Okay. And he's still experiencing delusions in your most
Objection.
recent.
All right, so that's
I'll
going
withdraw.
beyond the scope. All right.
One moment, Your Honor.
Mr. Filiatro?
Thank you. Doctor, you testified just now that when you met with Mr. Hardy on March 14th and March 15th, he presented the same way he did for Doctors Wood and Songer. Do you remember saying that?
Yes, very similarly, yes.
Right. He wasn't taking medication when he met with either of them, was he?
I don't believe so.
Right. You reviewed both of their reports before you wrote the March 14th report, correct?
Yes.
Right. And is it fair to say, reading those reports, Mr. Hardy has a history of refusing medications, doesn't he?
Mr. Hardy has a history of refusing medications similar to folks that have psychotic disorders, as I talked about just previously there.
Sure. I'm not asking about other folks. I'm asking about Mr. Hardy. All right.
Okay.
So,
Yes.
with regard to his own history, you mentioned you read the reports all the way back to 2023, correct?
There was documentation of diagnosis and treatment going back to 2023 in both of the initial competency to stand trial evaluations.
Okay.
Yes, that's what I was referring to.
Sure. And are you aware, I'm sure you're aware, that in 2024, he had a different court case where he was restored to competency through outpatient treatment, right?
Yes.
Yeah.
Yes.
Which involved medication, didn't it?
Yes, I believe he discontinued taking the medication at around that time for that case, if I'm not mistaken.
Well, but he was restored in outpatient treatment with medication, correct?
With medication, I believe that was offered to him.
Right.
He subsequently discontinued.
So, and he was aware that he was restored to competency, correct? If you know.
Objection.
I don't know if I can directly answer that question.
That's fine. Let me withdraw it. I want to ask about the defense question about sabotaging. I'd like you to please look at your report from July 21st. And this judge is State's Exhibit 8.
Objection, Your Honor. That is just limited to the March report when.
I think it's based upon your question.
This is based upon
Hold on,
sabotage.
Let me, before you ask the question, can you point me to which page you're looking at?
Page, it's on it, is page 12 of 31. Right in the middle, Judge.
Apologies, I'm having to go back and try to find this report. You know what, I'm just gonna pull it up in my email. Very good. All right. What page, sir, was that?
So it's at the bottom of the page, it says page 12 of 31.
Gotcha. Oh, it might be different because my formatting is different than what we sent. Do you know what section it says it in that you're referencing?
Psychiatry.
Gotcha. Okay.
And the line I want you to look at, it's only one line in this report I'm asking about. Dr. Dantonelli documented that Mr. Hardy stated, and there's a quote there that you quote. Do you see that?
Where at specifically under psychiatry? Because I have a few things here.
Okay. There's a paragraph that says, Mr. Hardy continued to work with. Do you see that paragraph?
It's under psychiatry, you said? Yes, I see it. Yes, okay. Yep.
So, right underneath that paragraph, there's one that says, Dr. Dantonelli documented that Mr. Hardy stated, and there's a quote.
Yes.
Please read that for us, and starting right there.
Is it where you say, well, guess I have to take it now?
Yes.
Is that what you're referring to?
Yes, it's your report. Do you see it?
Yeah.
Okay.
I see it.
So, and that's on April 2nd. So my question for you, Doctor. The defense raised sabotaging and your opinion that maybe Mr. Hardy wasn't. You've already said right here that he was restored to competency on a previous occasion through outpatient treatment that he voluntarily partook in, correct?
Based on my recollection of those records, yes.
Okay. And at your facility, he was refusing to take medications, correct?
Yes, early on in his admission, yes.
Right. And your facility requested to be able to force medications on him, correct?
Yes, I believe so. They applied for a forced medication order.
That order was generated on April 1st of this year, wasn't it?
Pardon me, but
The order was...
Yeah, he doesn't have it in front of
That's
him.
fine. And then on April 2nd, when the medications are being administered to him, he said, quote, well, I guess I have to take it now, unquote. Correct?
that's what's documented.
Right. So, doctor, someone who knows that they've been restored to competency before through medications, who is refusing to take medications, isn't it possible they're doing so because they're choosing to not want to be competent?
Hold on, you can ask the question and you can answer it. Go ahead, overruled.
Well, real quick, from what I recall, Mr. Hardy stopped taking his medications while he was on outpatient restoration.
Yeah, and I want to be clear, and somebody can correct me if I'm wrong, and this is some of the questions that I have, is that one of the questions I was going to have is, it appears that the medications that were trying to be administered, oral medications. My understanding that his outpatient treatment was having to do with injections that specifically don't require, they're more amenable to people with schizophrenia because of those issues. He was taking injections, and so the injections last, what, like 4 or 5, 6 weeks or something like that until they need the next one. And so he was able to be restored with injections, and it didn't require as much agreement with taking medications daily. That's my understanding. And so when we talk about this, there's a little bit of a difference there.
Sure. I want to get back to something else you said, Doctor, in your testimony from defense counsel just now. You mentioned during your testimony you were talking about treatment, and then you stopped yourself and then said attempting to treat him. Do you remember saying that?
Yes, through attempting to get him to be on board with taking medications.
Right.
I think that's probably what I was referring to.
Okay, so my question is there a difference between actually treating someone and just attempting to treat someone and it's not successful?
Well, generally, when we think of competency restoration treatment, it's, they come to the hospital, attempt, get them involved with groups, get them involved with individual programming, offering medication. Again, I'm not a medical doctor, but the psychiatrist or the treating medical practitioner offering medication that they believe might be helpful in treating some of those symptoms that's getting in the way of them being competent.
Yeah, I'm asking about your words you just said just now. You started saying they were treating him and you corrected yourself, attempting to treat him. Did you say that because he was refusing to take medications and so he wasn't being able to be treated until the forced medications order came?
Yes, I guess attempting to treat him with medications, yes.
Right. And that those attempts were not successful because he was refusing, correct?
He had been intermittent, I believe, in his compliance up until the time when the forced medication was ordered.
And that's something we should ask Dr. Dantonelli about?
Dr. Dantonelli would be more well equipped to talk about medication, yes.
Right. One moment, Judge. Thank you. Nothing further.
Anything based on that?
I have just one question, Your Honor. Dr. Hendrickson,
Yes,
was Mr. Hardy under a course of treatment the entire time he was at COBH?
when you say course of treatment, what do you mean?
I mean, was he being treated by people other than prescribing medication?
Well, I guess then we're getting into an argument about what treatment is, right?
Yeah. And there's...
I know that, again, Mr. Hardy was admitted on October 22nd of 2024, I believe, if I have that correctly. He met with individual providers. His initial doctor was Dr. Charles Foreman, had attempted to get him on board with taking medication to treat his psychotic symptomatology. He was intermittent with his compliance.
And he also met with therapists, social workers, SAMI counselors, correct?
That's correct.
Okay, and that's part of the treatment team at COBH, correct?
That's correct.
Thank you.
I do have a couple questions. How often did you meet with Mr. Hardy after his arrival? What was your schedule like when you met with him?
For my evaluation,
Yes.
for his competency evaluation. So I met, again, I met with him for the status report. That was the first time I met with him in March of 2025.
The first time you met with him was in March of 2025?
So because that's what, it was around then when it was assigned to me. I just want to make sure I got that right. Competency, yeah, so that report was dated March 14th, 2025. So I did my initial competency evaluation with him in March of 2025 when I was assigned to do his status report through our Office of Legal Assurance.
So you did not meet with him to get a baseline when he first arrived?
No, that's generally not something that we as evaluators do. Evaluators are tasked with evaluating their competency to proceed, if that's what we're looking at a very specific moment. That might be if the treatment team thinks the patient's ready.
And when you say treatment team, who are you referring to?
Psychiatrist, social worker, potentially a psychologist, adjunctive therapist, SAMI counselors, nursing as well.
Do you know how long Dr. Foreman was treating, up through what date Dr. Foreman was the treating psychiatrist?
Let me check. It looks as if Dr. Foreman was treating Mr. Hardy from the time he was admitted, he was the attending psychiatrist, until it looks like the end of January 2025.
And is that when Dr. Dantonetti picked it up?
Yes, Dr. Dantonetti met on January 24th, 2025 with Dr. Foreman to meet Mr. Hardy. At least that's what, that's what was documented in the progress note.
Okay. So there was some general discussion about reasons why people with schizophrenia do not take medication. Everything that I've read in here his cited reasons for not wanting to take medications were side effects. I haven't really read anything that, I mean, I can go through the different pages, but that he was citing any type of delusions for refusing medications. Every single time it's brought up, he brings up the side effects. Is there something in your report? I know that his delusions were preventing him from the ultimate issues, understanding and being able to assist his counsel and his defense because of some of these delusions, but was that specifically cited that for the reason why he wasn't taking his medications? Because the only citations I see was he didn't like the side effects.
Yeah, so generally speaking, patients with serious mental illness and psychotic disorder, the reasons why they don't want to take medications, they don't think they have anything wrong with them. So in the case of Mr. Hardy has pervasive persecutory and grandiose delusional thought content that he believes is in fact real. It's not related to medication, but it's related to the thought content. But he doesn't believe that any of that is, he believes all that's based in reality. And so his reasons for not wanting to take the medications, at least what I documented in the report, are based in reality, side effects, things along those lines. But his reasons for not taking the medication, he doesn't believe he needs the medication because he doesn't think that anything's wrong with him with regards to any of these psychotic symptoms. He doesn't believe he has a serious mental illness.
Okay.
In that way. That's okay.
Yeah, I mean, so I'm looking at it and I've seen some complaints about tiredness, some other side effects being lethargic, and so when asked specifically, discontinued medications shortly after he began taking it, citing problems related to side effects. I have some other pages in here. So when you meet with him, it was the first time was in March, and at that time you were informed by the psychiatrist that he was not taking any medications at the time that you met with him.
Yeah, again, I'd have to go back through here and double check, but I don't believe he was compliant with what was being prescribed.
And who's specifically speaking to him about taking these medications? Would it be nursing staff? Would it be psychiatrists? Who's the one that is, so there was an issue about rapport and getting patients to take these medications. Is it just somebody who's doling out the medications and then he denies? Because I'm wondering about what the standard is for refusal and what the protocol is to get somebody, essentially, I don't want it to be based upon the efficacy of somebody being able to convince somebody to take medications. Did they come around with everybody and give medications, and if there's a refusal, there's a refusal, or what's the protocol when there is a refusal?
Well, I'm not a treatment provider on his unit.
Right. Do you, because you reviewed the records, but do you know what efforts were made?
Yeah. So generally speaking, so nursing will make, the nurses are oftentimes the ones who are handling med pass. If a patient is declining medications, that will then get back to the treating psychiatrist. The treating psychiatrist is the one often who's continuing to, as I said before, attempt to instill insight into the patient to get them on board with taking medication to treat those symptoms.
Okay. And then, in your report, a recent course of treatment, I know you don't have the same page numbers, but it was documented that he discontinued his medication shortly thereafter, so you were informed of that by March. Your conclusion on page 26 states, the available evidence indicates that historically, when provided with a psychopharmacological treatment regimen, it has been documented to evidence some symptom remission. Mr. Hardy is not currently taking any prescribed antipsychotic medication However, his treatment team relayed to me that a forced medication order would likely be applied for through the court. Was it in March when this was first relayed to you, or were you the first?
That was around the time when I met with him for that initial status report evaluation, yes.
Okay. All right. And it's your understanding that it would be the nurses that attempt to dole out the medication, and if it's refused, it's just refused?
Nursing staff is generally the ones who are handling MedPass, yes.
Okay. All right. Anything based on my questions?
No, Judge, thank you.
No, Your Honor.
Okay. All right. Is Dr. Dantonetti, do we need to take a break to go get him?
Yes, and we are going to need, let me speak through. I'd like to ask the court, if it was the defense counsel's desire to have his treating physician testify, did the defense counsel get defendant's consent ahead of time?
So it is defense counsel's request to have Dr. Dantonetti testify, and the issue of consent, this is not an issue for this court to decide, because he is, by all the doctors up until this point, still considered incompetent. So that relates to the issue of consent. Your treatment team has been engaged to opine on his competency and his treatment. Therefore, consent is not an issue. Do you understand?
Your Honor, the treatment team is not tasked with evaluating his competency.
No, he's not. They're not. However, this is an issue regarding to his treatment, to determine whether or not he has been receiving the treatment necessary and when it started and stopped. It is a legal question that Dr. Dantonetti has already given a written opinion and submitted to this court.
I'll respectfully say that reports are different than testimony. I'm just reiterating the concern about the physician-patient privilege. It looks like what the parties are asking for are start and stop times of medication. Dr. Dantonetti could provide that in a report. If the court has specific items they are looking for him to provide from the medical record, he can provide that information to the court.
Dr. Dantonetti submitted a report to this court. We're asking him to testify consistent with his report. And specifically, there are some dates in here that are just general, and so we would be, I'm sure the parties are going to be asking, and this court is interested in those dates as well. So he submitted a report to this court. He's been engaged for purposes of determining the appropriate treatment to be able to restore for competency, and I'll read from the code section again.
Your Honor, that's not necessary. We would ask the court to order Dr. Dantonetti to appear and provide testimony for the limited scope of what you're seeking, if you could document that on the record.
Okay. So again, all the doctors and Dr. Stauffer were all copied on all of the scheduling emails. He submitted a report. The fact that he is not on notice that he's going to be testifying to the only thing that he's opined or submitted into this court. If you want me to issue an order right now, I can do that. But he has been on notice, he consented, and your entire staff has consented to this date, and we're all here for that date.
We are raising a legal issue at this time. The concern is the physician-patient privilege. If the court would like to order Dr. Dantonetti to testify.
Yes, I can issue the order right now.
Thank you.
You can, everybody can take a break, and we'll wait for him to get on the screen. Russ? I just realized, I just went to go put in this order, and I realized that when I said my order from earlier today, and you had a funny look on your face, I never hit the sign button.
Oh, yeah, because I was wondering.
I went to go put in this order, and I never hit the sign button. I'm sorry.
Oh,
That's my fault.
okay, I was wondering, like,
It's just, it was basically just reiterating what I had said on the record, but you gave me a funny look, and I was just like, I did this, I never hit the sign button.
Was that just, I mean, for both? None of us got it?
No, but you had the, I was like, I know I did this, and I just didn't hit the sign
I
button.
checked that docket.
Sorry, that's my fault, it was a mistake.
Yeah, there's like,
Dr. Dontinetti has previously submitted reports regarding his treatment of defendant and is required to testify to his reports and to answer questions put to him by counsel in the court regarding his treatment of defendant. Okay?
Thank you, Your
All
Honor.
right, thank you. Is he there?
Yep.
All right, Dr. Dontinetti, if you could please raise your right hand. Do you swear that your testimony will be the truth, the whole truth, and nothing but the truth, as you shall answer unto God?
I do.
Okay. All right. You submitted a report dated so you signed off on the report on 3/18/2025, and then you submitted another report July 10th, 2025, regarding the court order to update. I believe that those are the only two written reports. Is that correct, or is there another one? I believe those are the only two, correct?
Those are the two we've got, Judge, yes, thank you.
And it appears that some of your reporting or some of your treatment has been at least documented in others' reports, specifically Dr. Hendrickson's. So the council is going to ask you some questions about those reports, and if you need to refer to any other information, please let us know, and we'll go from there. Okay, go ahead.
Your Honor, I do want to swear him in, please.
Oh, yes.
She
Dr.
did.
Dontinetti, if you could please raise your right hand.
She did.
Did that?
You did.
Okay, thank you. You were sworn in. All right, go ahead.
Thank you. Hello, Doctor. My name is Kevin Filiatro. I've got some questions for you. Do you recall testifying over Zoom on March 31st of this year?
I do.
Okay. At that time, you testified that Delonte Hardy refused to take medications beginning in November of 2024 all the way through the end of March 2025. Is that true?
That's true.
What is the date on which he last took medications in November of 2024?
I will have to refer to the notes to know the exact date, but I was not part of the treatment team at that time.
It was
From
not,
what I could
hold on,
recollect
sorry,
from
one
the
second,
notes-
hold on.
Stop.
Sorry, it was not part of the what?
I was not his treating physician at that time, but from what I could gather from the notes, it was the last week of November that he stopped taking the medications.
If you could, do you have those notes handy? If you could give us the date?
I do not have it handy now.
Okay. So you would say it's the last week in November of 2024.
That's right.
And then he didn't take any medications in December of 2024, correct?
Correct.
No medications in January of 2025, correct?
That's correct.
No medications in February of 2025, correct?
That's correct.
And no medications in March of 2025, correct?
That's correct.
Okay. And are you the doctor that signed the paperwork requesting the ability to use force to give medications to Mr. Hardy.
Yes,
And that order came through after the hearing on March 31st, correct?
that's correct.
Okay. Now, on April 2nd of this year, did you take that order and begin forcibly administering medications to Mr. Hardy?
That's correct.
And when that happened, did he say to you, well, I guess I have to take them now?
That's correct.
In your, Judge, I'm going to refer to what's been labeled State's Exhibit 5. Doctor, this is your application to authorize involuntary psychotropic medications. Do you have that handy?
I don't have it handy with me.
Okay. Well, let me see if you recognize what I'm going to... Do you recall signing this on March 18th, 2025 at 7:45 a.m.?
I'm not sure about the date and time, but that sounds around,
Okay.
right?
So I'm looking at this, and it has your signature and then that exact date and time next to it. Does that sound about right?
That's right.
Okay. So I'm going to go up. Your Honor, I'm looking at a page that has attachment A and then number 2 listed. I'm going to read what this says, doctor, and tell me if you recognize it. This says, without medication, the patient's psychotic and affective symptoms will not improve, such that an indefinite hospitalization will be necessary for the safety of others.
Hold on. I'm sorry. Are you reading? Dr. Donnetti did participate in the forced medication order, but he is also the treating physician, and so the court order needs to delineate between, you're asking for testimony about the process regarding the forced medication order, but with respect to any other treatment, I'm going to respectfully request that defense get the defendant's consent before any testimony proceeds. If you're looking for other information, the court can request that information. It can be provided in a written report.
Ma'am, I'm reading a document your client signed.
This is a written report, his written report. I mean, so.
From which date?
Again, you know, this, the administration there were all put on notice weeks ago. We scheduled based upon the doctor's availability for specifically, so, I mean, if you could get his report.
We were provided no notice,
Okay, that's
no purpose,
inaccurate.
no scope for the hearing. I am concerned about
All right,
the law
if
here.
you could pull up his, if he could pull up his report, or, I don't know how to get it on the screen right now, so to share screen, it's his report that he authored and signed. If you could,
Let's take a moment so we can see what reports we're talking about and which role.
Do you have access to the report somewhere?
How do you get copies of your reports?
Do you have a jump drive anywhere?
As administration for them.
There's 3 of them sit right here.
All right, load it on a jump drive and put it in the Mondo pad.
You're gonna.
I don't have the mouse.
Yeah.
Thank you. Okay. Sorry. Go here. don't know if they can see this.
You have to hit share screen.
Where do I
So
see
go
that?
back, go back to the Zoom. There you go, and then share. Down. And then click that left button right there. Yeah, right, yeah, that, so click that window.
Wait, this?
No, 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 click that window there, choose that one, and then click share. And you can close that toolbox on the left, give them more space to see it, on the left.
On the left. Oh, here we go. Okay. Can you see this, doctor? You're muted.
I can see it.
Very good. Do you recognize it? I can scroll up for you if you need to see. I'll scroll up to the page above it. Do you see your signature there, sir?
I do.
Okay. And so now we're on the next page. Do you see where it says attachment A?
I see it.
And then number 2 here. Do you see that?
I see.
Okay. Do you recognize this document as something you signed?
I do.
Okay. So I want that, I'm looking at that paragraph that begins without medication. That was the paragraph I was reading. Do you recognize that paragraph?
I do.
All right. Doctor, looking at that paragraph, is it fair to say that Delonte Hardy, his treatment included both medication and attending classes and things of that nature?
Yes.
Okay. And so where you say here, without medication, the patient's psychotic and affective symptoms will not improve, such that an indefinite hospitalization will be necessary for the safety of others. That's true, isn't it?
That's true.
Okay, next sentence. This patient has a history of non-compliance with medications and medical procedures, such as blood work, urinalysis, x-rays, or EKG, such that an authorization by the court for forced treatment will be required for both the medications and the medical procedures in order for the patient to have a chance of recovering. That's true, isn't it?
That's true.
Okay. Doctor, since,
Can you take that down?
yes, we can take this down, thank you. Should I just hit this, Judge?
If you want to, unless they want to use it, but go ahead.
All right, I'll keep it like that.
I'm sorry. These reports are not on your docket. Are they on your docket?
No, they're not on the docket because again, okay.
These are confidential reports.
You asked to see them, and so we shared.
Yes, I know.
All right, so
I think-
all right, Mr.
You have the report. You're asking him to read a report into a public record that you already have.
Because
So I'm not sure the purpose of why we're reading a confidential document.
Judge, I'm objecting to this attorney
I'm
interfering
gonna-
with these proceedings.
I am. So, Miss, again, we have to have your doctor testify. If he can't remember or does not have his own reports in front of him and he can't ask questions, the parties can help him recall what he's saying in his reports. You said you didn't have them, we provided it for you. These are reports that he must testify to. It was specifically asked if he recalls and he wasn't sure and he didn't know. And you asked this state's attorney to provide the report. And I said, do you have it there? You said, no. I said, we can provide it for you. He's going to answer questions based upon the report that he authored. So again, this is, I don't recall ever in the history of the 9+ years that I've been doing this to have counsel tell this court based upon its ability to find whether or not somebody's being treated pursuant to the statute or treated properly for the competency hearing issues. Right now, we're determining a legal issue regarding tolling and whether or not defendant has been compliant with his treatment. That is a question of this court that your client, or I mean, not your client, you are representing him, but this treatment facility has been engaged to do. He submitted a report, and by statute, he can testify to the findings in his report.
Judge, I just want to put something else up here. This is the first page of this document. This is a letter from COBH to this court asking for a hearing on the attached paperwork.
Yes.
All right, just making a note of that.
Your Honor, I'm just clarifying that this particular physician is a treating physician, and so there are blurred lines here.
All right.
I understand you ordered him to testify.
Ma'am,
I will not interfere, I'm just expressing my concern.
You've made it known, and you can file anything that you would like, but at this time, I'm ordering the doctor to testify.
Doctor, last few questions. You asked for the ability to use force to administer medications. We had the hearing, and that ability was given to you, correct?
Correct.
Since that time, has the defendant been taking medication?
He's taking the medications.
Okay. And has he improved? That's yes or no?
Yes.
Okay. So is it fair to say medications are essential to the treatment he was sent to COBH to have for restoration to competency?
Yes.
Nothing further.
Hi, Dr. Dontonetti. My name's Chris Julian. I'm one of the attorneys representing Mr. Hardy. So, doctor, as the treating psychiatrist, you deal with the forensic patients there at Moritz, correct?
Correct.
And what are your duties when you're dealing with the forensic patients there?
I treat their mental illness.
I'm sorry, can you say that again?
I treat their mental illness.
Okay. And are you responsible for their restoration to competency?
I'm not.
Maybe if I rephrase that, do you oversee their entire treatment plan in order to restore them to competency?
I do.
Okay. And you are just one of the professionals on that restoration to competency team, correct?
That's correct.
Okay. But as the forensic psychiatrist, you're familiar with the laws of Ohio and how long you have to restore somebody to competency, correct?
I'm not a forensic psychiatrist. I'm just a treating psychiatrist for the patient.
I apologize, but you are aware of the statutes, correct? You look like you're having trouble understanding me. Can I clarify? You know that on a felony 1 or felony 2, the law provides 1 year to restore him to competency, correct?
Correct.
Okay. And when a patient first arrives at Moritz, do you work with the entire team to develop a treatment plan?
That's correct.
Okay. And involved in that plan is yourself, correct?
Correct.
Social workers?
Yes.
Nurses?
Correct.
Educational providers?
Correct.
Anybody else?
There will be psychologists. counselors.
And is the patient also involved?
True.
Okay. And when Mr. Hardy arrived in October, you were not his treating physician, correct?
That's correct.
Okay. So, although you reviewed Dr. Foreman's record, you don't know exactly what was going on with Mr. Hardy at that point in time, correct?
That's correct.
And I believe you said you took over his treatment in January.
February first week.
First week of February? Okay.
That's correct.
And in February, when you took over his treatment, he was not taking medication, correct?
That's correct.
And that you know for sure, because you were the treating doctor, correct?
That's correct.
Okay. When Mr. Hardy first arrived, since you weren't his treating doctor, did the prior doctor prepare a treatment plan for him?
He did.
And is that something that when you took over, you revised?
Yes.
So in other words, you came up with your own treatment plan, correct?
That's true.
Okay. And to do this, you also had to work with all of the same professionals we already discussed, right?
That's correct.
And with Mr. Hardy himself, right?
Right.
And this treatment plan, obviously your mental health treatment is one of the components, correct?
That's correct.
But the rest of the treatment involves classes, correct?
That's correct.
And those classes, there's some legal classes, right?
That's correct.
Some substance abuse classes,
That's correct.
some classes on mental illnesses.
That's correct.
And those classes on mental illness, are those designed because many of your patients don't understand their illness?
That's true.
And the goal of the treatment plan is to restore the patient to competency, correct?
That's correct.
So all of the parts of that plan are necessary in order to return somebody to competency, correct?
That's correct.
So in other words, you know that restoration to competency involves that they understand the nature and objectives of the proceedings, right?
Yes.
And in order to do that, they must participate in the legal classes and the social classes and the meetings with psychologists, right?
That's true.
Okay. And then you know that the patient also must be able to assist in their defense to be found competent, correct?
That's correct.
Okay. And this is the part, quite frankly, where you come in the most, correct?
I can say yes.
Okay. But in order for a person to be opined competent, they have to meet both understanding the nature and objectives of the proceeding and being able to assist in their defense, right?
Pardon me, but I'm not a forensic psychiatrist, so I'm not sure about these questions.
Oh,
Like, what are the components for them to be found competent? I'm not sure about them.
okay. But for your part, you need to make them understand their mental illness, correct?
That's correct.
Okay. And you've had cases previously where a client could have been found competent without medication, correct?
Specific to, I want to make sure we're talking apples to apples with schizophrenia.
Just generally first.
Okay.
It is possible.
Okay. Now, we all concede that Mr. Hardy does require medications, but generally, it is possible that somebody could be restored to competency without medication, right?
Yes.
So doctor, first of all, Mr. Hardy is diagnosed with schizophrenia, correct?
That's correct.
And one of the hallmarks of schizophrenia is the belief that they're not sick, right?
Need not be all the time.
I'm sorry, could you repeat that?
Can you repeat that?
Sometimes.
Okay. But patients that are diagnosed with schizophrenia, it's not uncommon for them to not take medication, right?
Objection.
Overruled.
When they don't have the insight, they don't take the medications.
Okay. Doctor, can you explain what you mean by insight?
When lack of understanding of their mental illness.
I need to repeat it.
Can I believe you said lack of understanding of their mental illness, right?
That's right.
Okay. So it's not just being difficult, right?
That's right.
So,
I know you're asking general questions, but we're running low on time. Can you ask it specific to Mr. Hardy? Because that's what
absolutely,
we're
Your
here
Honor.
for. So if you want to go
So-
back, go ahead.
No. So, doctor, there are several reasons why patients resist taking medications, right?
That's right.
Let's just ask for for Mr. Hardy.
And Mr. Hardy's diagnosis of schizophrenia includes delusions as a symptom, right?
That's right.
Okay. Can you tell us what a delusion is?
A delusion is a false belief that the patient adheres to, irrespective of the proof to the contrary.
So do patients suffering from delusions, Mr. Hardy, for example, does he know that those are delusions?
No.
And some of Mr. Hardy's delusions specifically are that he's being poisoned, right?
That's right.
And his food smells funny is something he complains about, right?
That's right.
And he believes people are out to get him, right?
That's right.
And in your opinion, doctor, are these things true?
I'm sorry, I didn't understand the question.
Yeah. Are they based in reality?
They're not.
But does that mean that Mr. Hardy doesn't believe them?
Objection. May we approach?
Sure. Judge, before we start, the microphone on the side.
Sorry, I think also this microphone.
Oh, gosh.
Judge, if I may, you're going to make your determination based on which parts of this are compelling to you. However, I do think that part of the defense's argument here is that none of this restoration process was disturbed by any willful sabotage-like actions on Mr. Harvey's behalf. And so I do think it's incredibly important for us to make the record that he was reluctant to take medication that was related to symptomology versus sabotage. We have a right to go back.
I agree that we do. However, I'm looking at this opposed. And yet, there's competing interests of this here. Not without the official. At the same time, we were all under the assumption based upon, it took me and we were back in the report and we also came to just to ensure, because I assumed that I should assume anything. So when I went back and read it, it was in black and white. That this is what it requires. And so it says medication in exactly.
It's, I think, if I may judge, if there has been medical, psychiatric reasons for them to have delayed in requesting it based on the symptomology he was presenting at the time prior to and when they asked for the order, then that's also a relevant question in particular to this here.
The issue is that delusions are being used as a shield and a sword. So you're saying his delusions.
He's sick, Judge.
But you can't, but here's the thing, for the purposes. But that, this is my point, is that you're using it as a shield. That is what you're saying. He's so sick that he's not taking his medications. He's not taking his medications because of his delusions, but at the same time, well, he can't take these until he's medicated, and then these delusions go away, and then we can understand his treatment on the education part. The other thing is that you have to take this holistically as well. There is documentation because this is particularly submitted out in the community, and so I have to take multiple reasons why someone is not doing it. And most of the documentation that we have is in the side. That's not even the
Yeah, I think the question is that some of the side effects are somatic and based on somatic delusions.
I didn't know that specifically. It was hardly how many months do you think is?
I don't think that's for us to answer that question. It's for the treating physicians.
This is why we're having this hearing. But at the same time, I think these questions are still appropriate. So to use this approach for action, they're still appropriate to determine what happens. What is required to treatment? There is an issue here that we cannot resolve. I think as Martha said, changes to the treatment. The physician.
Physician to the state and the court to dictate treatment. I'm sorry. Both parties stipulated to those first requirements. That's it. Medication and treatment.
No one on the defense is suggesting he doesn't need medication. What we are asking of the doctors is when it was appropriate to take certain medications and when it was appropriate to ask the court for assistance in that regard. We haven't, I didn't make that.
Could you have the link there?
My point is that there's a reason why the term starts when the treatment starts. There's a reason for that. So that's the reason for treatment includes medication that hasn't started yet for whatever reason. Maybe because they couldn't transport him to the facility and it took him 30 days or a month or whatever it is. Or he got there and he had a medical issue in which he had to be treated for a condition and he couldn't take those medications. And so the treatment was delayed. There are lots of different reasons why somebody's not getting appropriate proper treatment. It hasn't been turned out. But so that I need to have that count against the state and somebody's not being treated in order to be restored.
But that, we're not agreeing.
I'm not in not
We're not
agreement.
agreeing with the state, it's just for the record. He was receiving treatment. The question then becomes medication. What doctor's discretion when they should see for medication. Period. That's what the issue is. It's not the fact that he wasn't taking it. He was taking it when he first got there.
No.
Two pills. He refused. Two pills. Testimony.
I don't know that
Did your doctor
two pills was
said
enough
he
to
has
cause
that?
that.
Your doctor said he has to have this. He didn't say go down there and talk. Yeah, and you stipulated that in open court, and now you're completely back.
No one is backing up on that.
Yes, you are. Through this argument.
You know, I think it's interesting to argue that I think there's just, I don't think we are, if I just may. It's not just, we're not just saying he went to classes, and so because he was going to classes, but he wasn't taking medicine, he's still participating in part of his treatment. He's still meeting with the psychiatrist who is developing a relationship to try and give him insight into his own mental illness to come to a point when medication can appropriately be given. Let's extrapolate your argument out. Let's say there's a psychiatrist that wants to take a year to do so. Well, it's
Whether it's statutory or not. We know that. We have his insight. It's the quote, April 2nd. I guess I have to take that.
No,
Your
that's not
argument.
his
That's
insight.
not
But
his
what I'm
insight.
saying is,
That's
there are, that's a different argument. There are things that you have to require this person to plan and outsource medication. Should be given. This is, that's determination to argue against it, to into, and there's some doctors, they force medications required to be able to restore the sharpness. The question is if you go by your argument is, how much time does an individual psychiatrist get with finding a note that somebody's using medications? Could be months, could be 11 months.
Even medicine doctors get you a day early, not just lawyers deciding on medication being prescribed. They haven't given you one doctor that said it should be earlier, Tom. Your doctor said. No, she didn't give a day. She said a day.
Literally. But not on a part of minutes. There's no doctor that said, as soon as he got in, he should have been on medication. We did the start and we're calling the patient and he's like, okay, patient, I'm going to and they take a month. We don't go to doctors and say, okay, wait, shoot me the first time we see a doctor. Like I said, they're going back on what they've agreed to. No, we're not, it's not. That's exactly what it's. I mean, for the record, we agreed to stipulate to what's that, 725. So get it straight. The finding. Get it straight. It literally says it. What's your word mean? Just get it straight. What's your word mean? Straight. We know what it, we know it. Yeah. You went right back. You know what it. Just get it straight. Get the record straight. Period.
Not writing right now.
Get the record straight. Why it's
All right, enough.
Okay.
All right. So, Dr. Dontinetti, we were talking about the delusions, correct?
That's right.
And I believe what we left off with was that those are a symptom of his schizophrenia.
That's right.
And that they're things that he believes, correct?
That's true.
And some of them are referred to as somatic delusions, right?
That's true.
What are those?
Mr. Hardy believes that sometimes he comes up with like some body issues like the pain, back pain, scrotal pain and all that, which are not substantiated on the medical tests. And he also believes that he had some injury as a child and he has some concrete in his head.
Okay. And despite medical evidence to show him that those aren't accurate, does he still persist in his belief of those?
That's right.
Okay. But these are all things that you need to talk with him about, correct?
That's right.
Part of your treatment is trying to explain to him that these things aren't real, correct?
That's true.
Have you been able to persuade him yet that he doesn't have concrete in his head?
I could not.
And that's even today while he's on the clozapine, right?
That's right.
So just to go back one step here, doctor, when a patient first arrived, when Mr. Hardy first arrived at Twin Valley, he's evaluated by a doctor, correct?
That's correct.
And does that doctor...
Well, who was he evaluated? Let's just be specific. When he got there...
It was Dr. Foreman, correct?
He was the treating psychiatrist at that time.
Okay. And Dr. Foreman gave him a diagnosis, right?
That's right.
And when you took over, did you then have to re-evaluate him and come up with a diagnosis?
That's true.
So you wouldn't just read a prior doctor's evaluation and give him a diagnosis based on that evaluation, correct?
Correct.
Okay.
And I'm just going to jump in here because we're on the subject. What was the reason from switching from Dr. Foreman to you?
Dr. Foreman moved to a different position in the hospital, and I joined the hospital at that time.
Okay. And did you review Dr. Foreman's notes?
I did.
Okay. And do you know the first time about when Dr. Foreman met with him? So Mr. Hardy was delivered to the institution on October 22nd. Do you know when he first met with him?
I don't recollect the date, but it should have been on the day of the admission.
Okay. And do you know how often Dr. Foreman met with Mr. Hardy?
I'm not aware of that.
I'm sorry?
I'm not sure about that.
Okay. Well, what's the protocol for a patient that's there? Is it weekly? Is it daily? Is it monthly?
It's daily.
That the psychiatrist, so when you first took over in January, you were meeting with him daily?
That's right.
Okay. And when you reviewed those notes, did Dr. Foreman prescribe any medications for him based upon his diagnosis?
He did.
And what did he prescribe?
He prescribed 2 different medications at 2 different times. The first one was aripiprazole, and the second one was olanzapine.
And according to his notes, did he believe that it was necessary to treat these delusions?
Yes.
Go ahead.
All right, doctor, another reason why some patients are reluctant to take antipsychotics is because of side effects, right?
That's true.
Okay. And you reviewed Mr. Hardy's records, right?
That's true.
And you were aware that he's previously declined medications because he complained of side effects, right?
That's correct.
And that was even before he was charged with this offense, correct?
That's correct.
Right. And at some point in treating Mr. Hardy, he did express a willingness to take some medications, but not others, right?
That's correct.
Okay. And as his treating doctor, you're responsible for prescribing his medications now, right?
That's correct.
Okay. And when he expresses a willingness to take some meds but not others, is that something you would consider?
Yes,
And is that because the patient needs to be involved in their treatment, right?
that's correct.
When you're referring to other medications, what are you referring to? Are you referring to other medications that he was agreeable to other medications regarding his psychiatric disorder, or are we talking about aspirin?
No, antipsychotic medications
So he was agreeable to taking other medications?
at some point.
What?
Doctor,
Go ahead,
That was the question.
Dr. Johnson.
Since I have been his treating physician, he has not expressed that desire to take a different medication.
Are you aware of him expressing a desire to take other antipsychotic medications? And
I'm not aware of them.
Okay. And some of the side effects that he discussed, we've already previously discussed, right?
That's true.
Some are delusional, right?
side effects of the
Antipsychotic medications.
side effects of the antipsychotic medications, or
Antipsychotic medications.
That's right.
But many of the antipsychotic medications do have serious side effects, right?
They have the potential for side effects.
Okay. And this is well documented, right?
That's right.
And that's why it's so difficult to treat mental illness, because different medications work differently for different people, correct?
That's correct.
And even the same person may be able to take the same medication and then a month later have a side effect to that medication, right?
It is possible.
Okay. So, Doctor, we talked a little bit about, or let's talk a little about what Mr. Hardy's resistance to taking medication looked like. We already know that he was resistant to taking them, and we hear he's refused to take his medication. Did he ever physically assault anybody trying to give him his medications?
He did not.
Okay. He merely indicated that he wasn't sick and he didn't want medication, right?
That's correct.
Or he may have indicated that they were giving him side effects, right?
That's correct.
All right. And regardless of the origination of those side effects, they were real to Mr. Hardy, right?
That's correct.
So, Doctor, Mr. Filiatro talked to you a little bit about the petition for the involuntary administration of medication, right?
Right.
And that was the form that you filled out and submitted to the court in March, right?
That's correct.
Okay. And I think we've already established that the involuntary administration of medication can be used in restoration to competency, right?
That's correct.
Doctor, are there any timelines that Twin Valley has concerning when you need to file an involuntary administration of medication order or request for an order?
I'm not aware of any such timelines.
Okay. So does the hospital leave it up to the treating doctors?
That's correct.
And that decision is made by yourself?
That's correct.
And is it made in conjunction with the other professionals?
That's correct.
And when a person is not competent to make their own healthcare decisions, then the hospital's obligated to petition the court to make those decisions, right?
That's correct.
And is it fair to say that the hospital, Twin Valley in particular, would ask for an involuntary administration of medication sooner for patients who are unable to participate in other components of their treatment plan?
I'm sorry, I didn't understand the question.
I'll rephrase that. at Twin Valley, there are some patients who, because of their mental illness, cannot participate in the restoration to competency classes, right?
Correct.
And those people, is it fair to say, often are brought to court for an involuntary administration of medication order sooner?
I should say yes.
Okay. And is it fair to say that the involuntary administration of medication request is made sooner for those patients who pose a risk of harm to themselves or
I'm
others?
sorry, I lost you.
I'm sorry.
It's fine. I thought it was fair to say the involuntary administration of medication request.
Is made sooner for patients who pose a risk of harm to themselves or others.
That's correct.
Okay. And doctor, isn't it true that when some people arrive at Twin Valley, they're actively hallucinating and reacting negatively to those hallucinations?
That's correct.
And being disruptive of the facility, right?
That's right.
And this was not Mr. Hardy's presentation, right?
Again, I was not his treating physician when he first came in, but I did not get any such information from reviewing the charts.
Okay. And in reviewing the charts, was there any indication that he was regularly acting out in an aggressive manner?
No.
Okay. And was there any reports of him repeatedly threatening staff or other residents?
No.
People with exhibiting these behaviors would more likely be brought to court for a involuntary administration of medication order, correct?
That's correct.
And doctor, there's also some people that are smearing feces at the facility, right?
That's correct.
And again, that was not Mr. Hardy.
That's correct.
Okay. All those different symptoms, those people, the patients exhibiting those, need the involuntary administration of medication in order to participate in their treatment classes, correct?
Can you please repeat the question?
Sorry, that was terrible. So, patients who have the symptoms that I just laid out, the smearing feces, the being aggressive, the acting out, because of their presentation, those people are not able to participate in the restoration to competency classes, right?
Right.
Okay. But Mr. Hardy did participate in the restoration to competency classes, right?
That's right.
Okay. And in your review of the records from arrival in October until roughly March, when the request for involuntary medication was made, he was participating in his treatment plan, correct?
The treatment plan includes medications. He was not taking the medicine, so he was not fully participating in the treatment plan.
But he was participating in classes, right?
That's right.
Objection.
The record will reflect the answer. Overruled.
He was participating in those classes, wasn't he?
He was.
Okay. And he was even taking quizzes and tests in those classes, right?
That's right.
And he was doing well on those, if you know.
I'm not aware of how he was doing.
I'm sorry, can you repeat that?
I'm not aware of how he was doing in those classes before.
But at some time, doctor, his participation in these things fell off, right? He stopped doing those things.
That's correct.
And was it at this point that you decided it was necessary to petition the court for an involuntary administration of medication?
It was around the same time, but it was not the only reason.
It was not what?
It was not the only reason the petition was filed.
Why else was the petition filed?
Because of his delusions.
Were you, without medication, how were you trying to treat the delusions?
We cannot treat the delusions without the medications.
Were you, how were you working with him?
I was trying to develop rapport with him, explaining the importance of medications. But once I realized that, it was not going anywhere, I filed for the petition.
Okay. So from the time you took over his care, part of your treatment was to build a rapport with him
That's right.
and to try to convince him to take medications.
That's right.
And are you aware if this was the same thing Dr. Foreman was doing?
I believe so.
So Mr. Hardy's not the first patient to be reluctant to take medications, right?
That's right.
And it's not the first time that you've requested the involuntary administration of medications, right?
That's right.
But actually, this is the first time you've testified in a hearing like this, right?
That's right.
So as the physician that requested the administration of medications, you know what standards you must meet, right?
That's right.
So are you familiar with the term the cell requirements?
I'm not sure.
Okay. So you know that at least one of them is...
It's referring to a court
Right.
case. I
Right.
think there's a statutory, okay.
Right,
It's
basically
codified.
the requirements that you need in order to obtain the administration of medication over objection, right?
Sorry, can you answer verbally?
I'm sorry, can you please repeat that?
Yes, so you're familiar with the requirements necessary to obtain a order for the involuntary administration of medication, right?
That's right.
Okay. That has to be an important government interest, right?
So that
And I was gonna say-
that part is for the court to decide, not for him to decide.
And I was going to say, that's one of the ones that you don't necessarily, but one of the things that you're required to show is that the involuntary medication is substantially likely to render the defendant competent and unlikely to have side effects that will interfere significantly with his ability to assist counsel. Right? You're familiar with that, right?
That's right.
Okay. And you're also familiar with that it has to be no less intrusive means.
That's right.
And it also has to be medically appropriate and in the patient's best medical interest.
That's right.
All right. So when we came to court in March, those were the factors that you were prepared to testify about, right?
That's right.
Okay.
Ms. Julian, about 5 more minutes.
So doctor, from the time of Mr. Hardy's admission, I'm going to strike that. When you were questioned about the court during that hearing for the administration of medications, you were asked about what efforts you had made to try and gain compliance by the defendant. And you said that both you and Dr. Foreman explained the benefits of medication to him. What do you mean by that?
Explaining to the patient what his symptoms are and how the medications can help with them.
And did this also include the importance of building a rapport with the client?
That's correct.
Is it fair to say the purpose of that was to try and get him to buy into his need for treatment and for medication? I'm sorry.
That's correct.
And ultimately, that order was granted, right?
That's right.
All right. And Mr. Hardy did not appeal that order, did he?
I'm not aware of any such appeals.
All right. And Mr. Filiatro kept talking about forcibly administering the medications. That's not what this looks like, is it, doctor?
Can you please repeat the question?
So let me rephrase it. We often refer to the order that you received as a forced medication order, right?
That's right.
Okay. The picture that lay people have is that we are strapping Mr. Hardy down and giving him an injection. That's not what happens, is it?
That's right.
Okay. He is provided with the medication by the nurse, right?
Yes.
And he takes the medication.
That's right.
Okay.
If he refuses to take the medicine, then he will be administered an injection.
Okay. And that has not happened in Mr. Hardy's case, right?
It does not happen.
Okay. Just briefly here, you're aware that there's been a qualifier added to, or perhaps were you the one that added the qualifier of treatment resistant to Mr. Hardy's diagnosis?
I don't remember me adding that
Okay.
in his diagnosis.
And what medication is Mr. Hardy on right now?
He's currently on risperidone, clozapine, valproic acid, and trazodone.
Okay. And isn't it true that clozapine is one of the medications that until recently required regular blood draws and EKGs?
That's true.
And this was all due to the potential for serious side effects, right?
That's correct.
And isn't it also true clozapine isn't generally available as an injection?
It's not available.
And doctor, you're aware that we are here today because the state of Ohio is asking the court to extend the time frame for Mr. Hardy to be restored.
And just to be clear, you're already aware that all parties agreed that the at least earliest date is now October 22nd.
Right.
So the request is to extend it beyond that, not what you initially thought. Go ahead.
So you know that's what we're here for today, right?
I was not aware of the purpose of this hearing.
Okay. And you're aware, based on their questioning, that the state of Ohio believes that Mr. Hardy is thwarting his restoration by voluntarily not taking his medication, right?
Can you please repeat the question?
The state of Ohio believes that Mr. Hardy is intentionally trying to prevent himself from being competent by voluntarily refusing to take his medication.
I'm not aware of that.
Okay.
Is that a question for him, what the state believes?
Well,
I would object.
that is, I mean, so in terms, I mean, you can ask him in terms of, you know,
I'll move on
can
to the
somebody
next question.
who's,
It's okay.
who's mentally ill
That's what.
voluntarily,
Yep,
I mean,
I
is it,
will-
does he refuse it or not voluntarily in the terms of somebody who's mentally ill is a whole nother, it's either he really is or isn't, it's the intention behind it is muddled because of the diagnosis.
Well,
I mean, you can,
so doctor, a voluntary choice is one that is made by a person with the capacity to make such a choice, right?
That's correct.
Okay. And you filed a request with this court asking for the involuntary administration of medications because it was your professional opinion that Mr. Hardy lacked the capacity to make that choice.
That's correct.
Okay. And you're aware that Mr. Hardy wants to be found competent, right?
Can you please repeat that question?
So let me strike that one and say, Mr. Hardy indicated to you that he wanted to be competent so he could, quote, use his freedom of speech to let the court
Sorry,
know.
if you're reading from something, can you use an exhibit?
It was the, which report was it? No, it wasn't that one.
What's the date?
I don't have the date on me. How about if we don't do the quote? It was in Dr. Hendrickson's report.
Okay, well, I just want to be able to.
Yeah,
look
it was
at
in Dr. Hendrickson's report where Dr. Hendrickson quoted Dr. Donnetti.
So that would be the March 14th report?
Yes, I believe so.
Just let me find it. Or the March 18th, what page are you on?
I'm not.
So that'd be State's Exhibit 4.
Karen, I can strike that one, quite frankly. I'm just about finished here. I have 2 more questions, if that's okay with the court.
Yep, yeah, it's almost 6 o'clock and the state has.
Like I said,
Go ahead.
2 more. Doctor, as of today, Mr. Hardy is still experiencing delusions that impact his competency to stand trial, right?
I cannot comment on the competency because I'm not trained for that.
But he is still experiencing the delusions, right?
That's right.
And to your knowledge, he has not been evaluated and found competent as of today.
I'm not aware of that.
Okay, thank you.
Mr. Filiatro?
Doctor, a few questions here. When Mr. Hardy first came to the facility, his doctor was Dr. Foreman, correct?
That's correct.
And Dr. Foreman made a treatment plan for Mr. Hardy, right?
That's right.
That plan had as part of it that Mr. Hardy had to take medications, correct?
That's correct.
All right. Has he ever had a treatment plan at this facility that did not require medications?
I'm not aware of any such plan.
Your plan had medications, correct?
That's correct.
Dr. Foreman's plan had medications, correct?
That's correct.
So, when Mr. Hardy refused to take medications, he was refusing an essential part of his treatment, wasn't he?
That's correct.
Okay. When Mr. Hardy arrived at the facility, he was having delusions, correct?
From what I reviewed in the notes, yes.
And it was your testimony earlier, you need medications to treat delusions, right?
That's correct.
Okay. So when Mr. Hardy refused medications, he was refusing the only thing that could possibly help with his delusions, wasn't he?
That's correct.
Doctor, who's in charge of the treatment plan? The doctors or Mr. Hardy?
It's the treatment team.
And if Mr. Hardy is able to refuse medications, he's able to refuse treatment, isn't he?
That's correct.
Okay. So when you got the order to allow you to use force to administer medications, is it your testimony the very first time you went to him, he said, well, I guess I have to take them now?
That's correct.
So that is when treatment began, isn't it?
Treatment with the medications began at that time.
And there is no treatment of Mr. Hardy without treatment of medications, correct?
That's correct.
So the treatment of Mr. Hardy began when he could not refuse his medications anymore, didn't it?
That's correct.
Nothing further.
May I just have 2 questions?
And just before that, so that you guys can ask based upon follow-up, there's some questions about my question that Dr. Foreman was, took another role, and questions about how you had to start your rapport with Mr. Hardy. If Dr. Foreman had remained, the restart of that rapport would not have been required. Would that be accurate?
I'm sorry, Your Honor, I did not understand the question.
So I'm essentially saying is that Dr. Foreman had already noted that he was not taking medications and that he would need a forced medication at some point. But when you came in, you had to make your own determination. Is that correct?
That's correct.
Okay. All right. So essentially, for lack of a better term, you had to start your own clock over.
I can say yes.
Okay. Go ahead.
Just, Mr. Hardy is also a part of the treatment team, right?
That's correct.
And doctor, did you ask for the court order for the involuntary administration of medication when you thought that it was appropriate?
Can you please repeat the question?
Yes. Did you ask for the court order for the involuntary administration of medication when you thought that it was an appropriate time?
That's correct.
Thank you. Nothing further.
Anything based upon that?
Nothing based on that.
Okay. All right. I think we're done. Just because there is statutory requirements regarding when we receive reports, I just want to put on the record the timing of this. So my bailiff first August 29th of 2025. We were informed that same day that Dr. Dontinetti is out of the office and is not scheduled to return until Monday, 9/8. Is it possible to hold the hearing the week of September 8th? Dr. Hendrickson was added to the email. Dr. Foreman was also on this email. Then my bailiff responded, I believe it would work. On September 2nd, he stated it looks like 9/12 at 1 p.m. for the hearing after he conferred with counsel. And with the doctors, Dr. Dontinetti on September 2nd, with Dr. Hendrickson, the administrator, all confirmed on September 2nd that September 12th at 1 o'clock would be the date for the hearing. It was further asked if others could join on it. I believe a chief medical officer, if they could join. I believe he reached out to, my bailiff reached out to the parties saying that there was no objection to that. So this, the facility had 10 days notice. Okay?
Your Honor, just one other thing. We'd like to mark Defense Exhibit A, the August 29, 2025 report. It's the only report the prosecutors left off of their exhibits, and it's one that happens to
I'm going to make for the record all the exhibits, and we can go over those. We'll have separate. Which number?
It would be Defense Exhibit A. It's the August 29, 2025 with the addendum that said our client, there was no evidence that our client
So this would be
any illicit substances.
this is. I think your pages are out of order here. Oh no, okay. All right, so this will be Defense Exhibit A.
State also did not admit August 25th.
We're going to admit all of them, so we'll
All
go, so this is Defense Exhibit A. I don't know which way you guys want to do those, but we have, because I referenced a few reports. I referenced Dr. Woods' report.
Sorry, what did you say?
I referenced.
Your Honor, legal, if I may, legal counsel was not notified.
Yeah,
of
the
the
legal
purpose of
counsel
this
is not
hearing
required
10
to be
days.
notified. Legal counsel is not
Well,
required to be notified.
Just for the record, our non-legal staff do not understand the legal implications of certain testimony.
I don't understand, I'm not responsible for the inner workings of how you're all notified. All we know is that we notify the doctors what the date is. I'm sorry that they didn't notify legal, but this court is not required to notify legal.
We got no official notice of hearing. Emails are informal communications. I'd just like the record to reflect that.
Sure. All right. So August 19th, 2024, that's Dr. Woods' report. September 9th, which is the court psychiatric clinic's competency stand trial evaluation. Do you want me to just make these?
Those are State's Exhibits 1 and 2 if you want to.
Oh, were they already?
Yes. I can list off what our exhibits are, Judge.
Oh, I do see this 1 and 2. Okay. I just want to make sure that we're not missing anything. Do we have the July 10th? We have that one.
That is State's Exhibit 7, the letter to the court, the 2-page.
July 21st.
That's State's Exhibit 8.
July 25th. We have that. August 25th.
August 25th and August 29th, we did not label because they were not.
Okay, that's
State's opinion pertinent to the pending motion.
Okay, but that's technically was referenced, and I think just as a matter of course, it should be part of the record. That's State's Exhibit A. Defense Exhibit A, excuse me. And then I do have, and this is up to you all, but we did discuss making these part of the hearing.
Maybe what part of the hearing?
Not part of the hearing, but part of the record just generally. There's emails, 5/6/25, that's regarding, because this is part of the communication from the facility to the court, which then I relayed to you all. And I know that there's some issue, that's why I ordered them to put everything in reports, but not everything was transferred, I think, to reports, but 5/6/25.
We'll object to the emails. Everything else we're fine with.
Okay. I mean, these are statements made by the doctors.
Understand.
And there was discussion about making this part of the record.
But we didn't agree to that, Judge. And the second thing is, if the court could respectfully make sure all the exhibits, including Defendant's Exhibit A, is under
Yes.
seal.
Well, I'm gonna send them with the court reporter, and she'll maintain those.
Okay.
And I'll put the order in, yeah.
Okay, thank you.
Was there the 2-page update, 7/10? Is that in here?
That's State's Exhibit 7.
Okay, all right, then I think, is everybody satisfied that we have all of the reports from the facility?
Yes, Your Honor. Thank you.
All right.
Is that 1 through 8?
Yes, States 1 through 8.
Okay. I just want to make sure we just didn't.
And then, counsel, if you want to engage our administrator to let the court know and all the other judges know if it is now required by COBH that attorneys need to be notified. That has not been the practice for as long as I've been here, over 9 years. And so if that is going to be a requirement going forward, you should either file something in this case or let our administration know that your policies and procedures have changed. Okay? And this hearing's ended. I'm going to issue a decision. It's late, so we can reconvene sometime next week.
That's fine, Judge.
Can I have the mouse, please?
Can I have this?
Sure.
Regarding the next court date, which is going to be posted on the
Yeah, we haven't decided it.
I figured that in here, so I was just making sure.
Yeah, unfortunately, okay.
Thank you, Troy. So I don't have my line within lines. Do you mind just signing it? I promise I'll fill this
Oh,
all
yeah,
in
that's
accordingly.
fine. Sorry.
I usually,
Do you need them to sign it?
yes, I will fix it. Wait, guys.
Kevin?
I'll get it. I need 29 signed. By both sides, I need 29 signed. The rule 29, local rule 29.
Oh, sure.
Anywhere on that. So are you going to be back there?
I'll just do it right now.
Oh, did Chris just go out there?
I'll get it. I'll get it.
Hi, ma'am. Just to clarify, you're going to reconvene with us next week?
Hopefully sometime. We have to set a date. I have to check with everybody to make sure that everybody's schedules.
And will that be continuing to question the doctors?
No.
You know what? I'll get it.
Not, well,
I'll
something
get
can
it
always
signed.
change. It's not intended to be.
Okay.
But
I
things.
just put judge will issue decision sometimes. It's not the right form. I forgot the signature lines on my form. I don't have it with me. So I will get it. Thank you, though.
Do you want this Zoom?
I think it's off, yeah.
Okay, so this needs to.
I have, where did Chris go?
She's not up there. No one is. from
Oh,
the
did they go in here?
I think they went there. Did they go that way?
Yeah, 'cause they might have gone into Judge Hagen's courtroom.
Oh, okay. Let me just make sure. Oh, here I have one. Signatures.
We all good?
I'm gonna have